inquiry into the application of the contractor employment agent provisions in the Payroll Tax Act 2007. Firstly, I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands of which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Jeremy Buckingham and I am the chair of this committee. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. Finally, I note the committee has agreed to hold a further hearing for the inquiry to gather evidence from gig economy stakeholders. The date of the hearing will be determined after the court's determination on the appeal in the dispute between Uber and Revenue New South Wales. To all of the witnesses, thank you very much for making the time to give evidence. We very much appreciate it. Could each witness, starting on my left with Ms Spinks, please state your name and position title and swear either an oath or an affirmation, please.
Certainly. My name is Amanda Spinks, Managing Director at Alvarez & Marcel.
Ms Spinks, can I just ask you to pull the microphone a bit closer or just point it? Yeah, that's it. It's just directional. That's great. Thank you.
Not a problem. My name is Amanda Spinks from Alvarez & Marcel. I'm a Managing Director. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much, Ms Spinks. Ms Abdallah.
My name is Julie Abdallah. I'm the Head of Tax and Legal at the Tax Institute. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. Mr Aquilina.
Jack Aquilina, Managing Associate, Denton's Australia, and I swear that the evidence that now I'm about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you very much. Would any of you like to start by making a short statement? Well, I'll start with you, Ms Spinks.
Sure. So, good morning, thanks for having us today. As I said, my name's Amanda Spinks. I'm representing Alvarez & Marcel. We're a global tax company and I've personally been advising on employment taxes for nearly 20 years. Any thoughts or recommendations I make today are obviously general in nature, but very happy to help with any specifics at a later date if required. Our submission highlights concerns that the current provisions, and particularly the current administration of those provisions, are overly broad. It's leading to unintended tax burdens on genuine commercial arrangements. Our proposed reforms would realign the legislation with its original intent, as well as simplifying compliance and providing clarity for taxpayers, the Chief Commissioner of State Revenue and the courts. Our recommendations fall into three key areas for reform. First of all, clarifying and narrowing the types of business arrangements that fall within the contractor provisions. The current approach is that all contractors start within the rules and they only fall out if an exemption applies. This creates an unnecessary burden for all businesses that use genuine independent contractors. Second recommendation is around simplifying those contractor exemptions. So once someone is within those contractor provisions, we can have a much easier way for them to fall out of those exemptions and apply them correctly. Again, the aim is to minimise the need for taxpayers to apply qualitative provisions and exemptions when they aren't necessarily privy to all the information that they need, and instead give businesses practical, realistic and actionable exemptions without any grey areas. Finally, suggest reverting to the original intention of the employment agent provisions by ensuring the employment agent provisions only cover those scenarios where workers are provided to be utilised by the client in the client's business. This could be readily amended by applying a clear and globally used industry classification. It's actually already in place and already used by Revenue New South Wales. In fact, Revenue New South Wales now pre-fills this information for employers in the annual payroll tax returns. Thank you.
Thank you, Ms Spinks. Ms Abdallah.
Thank you. Good morning. On behalf of the Tax Institute, I thank the committee for inviting me to give evidence in this hearing. The Tax Institute is an independent, not-for-profit education organisation with a diverse membership base of tax professionals, including lawyers and accountants from sole practitioners to large firms, academics and revenue officers across Australia. Our role is to educate members, government and the broader community on the tax system and to advocate for its improvement for the benefit of all Australians. Payroll tax is a significant source of revenue for New South Wales, accounting for approximately 30% of its total revenue, so it's important to get the settings right. The contractor and employment agent provisions were originally intended as anti-avoidance measures to bring to tax amounts paid in respect of in-substance employment relationships that are master's contractor arrangements. The evolution of modern work models, including the on-demand and gig economy, have introduced new engagements that blur the line between traditional employment and contracting. These practices have brought about new challenges in the application of these rules. Likewise, changes over time in the interpretation of the law by the regulator, adopting a more literal approach, have brought into scope long-standing arrangements that were never intended to be caught by the policy. The volume of litigation around these provisions in recent years and much of the court's comments clearly indicate the harshness and deficiencies of the current law. While amnesties and certain initiatives in New South Wales and other states have been beneficial for some businesses, they don't cover all affected arrangements, nor do they go to the heart of the issues that can only truly be resolved through legislative amendment. These provisions directly impact the viability of Australian businesses, and they've got broader public policy implications. They affect workers, consumers and patients, both in our metropolitan and rural communities, onto whom these costs are ultimately passed or who may lose access to fundamental services altogether. We need a sustainable, fair system that can accommodate an evolving economic landscape. The contractor and employment agent provisions need to be appropriately targeted so they do not capture bona fide independent contractor arrangements. Any amendments need to be designed with the principles of good tax policy in mind and with an aim of providing much needed certainty to taxpayers. Importantly, the input of stakeholders with expertise should be considered through consultations starting as early in the process as possible. Early stakeholder engagement involvement facilitates the integration of expert knowledge and ensures that diverse perspectives are taken into account. This approach can foster a better understanding of the real-life issues and potential challenges and help to identify practical solutions while aligning with the community's needs and expectations. I'd be pleased to answer any questions to assist the committee. Thank you.
Thank you, Mr Abdallah. Mr Aquilina.
Good morning, Chair, and good morning to all the committee members. It's an honour to be here today, and thank you for the invitation and for asking us to contribute. Put simply, our payroll tax system is broken. It's not achieving its objectives in being a tax only on employment, and it needs to be updated. The problem with our payroll tax system at the moment is it was conceived in a period of time before modern arrangements, whether we like them or not, existed. In fact, the very provisions that we're focusing on today existed at a time where we couldn't even contemplate or imagine the types of arrangements that technology platforms and the gig economy have made possible. So we have an opportunity to fix it. But I think one of the most egregious parts about the current operation of the system is that it's harming the most vulnerable of our small businesses. These are mums and dads, normal people that are trying to get ahead in the economy, who are pursuing opportunities that the gig economy is offering them to pursue their own employment, in addition probably to other work that they're doing as well. We need to protect these people. We need to make sure that the system doesn't unfairly place economic burden on them. Because let's face the reality. If we tax the big end of town on these measures, they're going to pass the costs down. These people are going to pay the bill. It's just unacceptable. So it needs leadership and reform, and I think the committee has shown that today. And I want to congratulate the Parliament on doing that. New South Wales has a unique role to play now in leading the nation on this really important issue. And we're proud at Dentons Australia to present not only the problem, because I'm sure you'll hear a lot about what the problems are, but also to make some suggestions about what the solution can be as well. We refer the committee to our proposed draft legislation that we've proposed to rebalance the measures away from a services test towards an integration and control test, which is probably familiar to many of you, particularly those who have worked in employment law issues in the past. And I think this is the opportunity now to consider what we can do to actually reform the system. So we're looking forward to working with you and assisting the inquiry in any way, and most importantly, to answering your questions. Thank you again.
Thank you, Mr Aquilina. We'll now turn to those questions, beginning with some from the opposition and Mr Tudorhope.
Good morning, and thank you for being there, and thank you very much for the quality of your submissions. I think they're of excellent quality. In view of the decisions which, Ms Abdallah, you have wonderfully summarised in your submission relating to the expansion of payroll tax, why isn't it the case that businesses which are now aware of those decisions should not be able to structure their businesses in ways that can now comply with the wording of the Act?
Thank you for your question. There are a couple of different aspects to this. So the number one, the policy underpinning those provisions hasn't changed, and the wording itself hasn't changed, but the interpretation has. So these businesses that may choose to then restructure to fit within the provisions or to satisfy some of the exemptions, some of them can't actually do that. They can't actually fit within the exemptions, even where they are bona fide independent contractors, and we've seen that in some of the court cases. But sometimes they may be at risk of other avoidance integrity provisions where they choose to restructure to avoid something else. So it can create more complications for them. The other issue is, I suppose the overarching issue is that they shouldn't be within scope in the first place, so they shouldn't need to restructure their arrangements where they are independent arrangements, where they are bona fide independent contractors. So all of these sort of things create work for these businesses. There's time and money that goes into restructuring affairs or trying to understand whether they are within or not within the scope of the provisions. These disputes cost money, whether it's not just the advisors that their costs, it's the resources of the business that are taken away from the business itself to try and manage these rules when it could be much simpler.
So you act for a large number of people who are in the advice industry. Why isn't it the case that those advisors should not be providing advice to their clients about their potential exposure to payroll tax?
Well, they do. So the difficulty is that while they can provide advice, there is a challenge with providing enough certainty given how things have evolved in recent times. But also, as much as they can give advice, some of the practical challenges that the businesses face in terms of the evidence that they need to collect and be able to demonstrate that they fall within an exemption are near impossible in some cases.
Well, is it the case, perhaps you have some knowledge of this, there is the ability, of course, to obtain rulings from Revenue New South Wales in respect of certain arrangements. In what circumstances have your members or your organisation sought rulings in relation to potential liability for payroll tax?
I would have to take on notice particular examples from members of rulings. How many? I couldn't tell you that off the top of my head. But the feedback that we do receive is that while you can apply for a ruling, it can be a lengthy process, it's a costly process, but from our perspective as the Tax Institute, looking at the system as a whole, rulings for individual businesses don't seem to be the preferred outcome or the preferred solution to deal with these issues. And I think it would be reasonably simple legislative amendments coupled with some administrative guidance from the Revenue that's consistent with a purposive approach, but that would indicate to New South Wales, to all businesses, what the rules are and wouldn't be on a case-by-case basis. It's also, I would think, preferable for the Revenue because it frees up resources in dealing with ruling applications to then have a consistent system across the board.
Have either of Mr. Aquilina, have you got any observation in relation to that?
Yes, if I may. In terms of the situation around why can't they restructure, the cost going through the system here is quite significant.
Yep.
And it's a question of economics. If these businesses are operating on low margins, which a lot of them are, if they absorb the cost, then the business doesn't exist. If they pass it on, then in a lot of cases, these small businesses that are sort of the recipients, the contractors per se, have a cut that's so significant they can't operate. So it isn't a question about a willingness for people to comply with the law. People want to comply with the law and do the right thing. And the duty of advisors, I mean, I see myself as a lawyer. My duty is not to be a puppet to my client, but to be an administrator of justice and to ensure that the law applies the way it's intended. And obviously that creates difficulties in structuring, because if the law's going to eliminate the business, then there's no business to restructure. So that's all I'd say on that point.
I think what I'd add as well is we're often consulted when a business is being set up or when a new arrangement is being entered into, and so we will provide advice at that point and we'll say the law seems clear, this is how it should be done, and we'd give advice.
Yeah.
But we've seen certainly with the cases, as soon as a new case comes along and they sort of change their interpretation, we're not necessarily being asked to reassert on a particular circumstance or to vary how an arrangement might change over time. All of my clients would always be trying to do the right thing, but as new cases come out, as working arrangements change, and we could advise on a particular arrangement and that particular contractor may change their circumstances unbeknownst to my client over the next few years, and so the payroll tax outcome should change even though my client never received any new information.
So after the decision in Optical Superstore, did you provide advice to any of your clients or any of your members in relation to the potential ramifications of that decision?
At the particular time of that case, I was not in professional services, so
Yeah.
I'm probably not the correct person to answer
the
that one.
organisation for whom you work.
Certainly there were people asking advice, and plenty of people in the industry were asking, and it was always, I think, an area where different arguments could be presented, and I'd have to take on notice what particular clients were doing.
What about you, Ms. Abdallah?
The Tax Institute doesn't provide advice. So I am a lawyer, but we don't give advice. We're an education body. So we do put out materials that will assist our members and the broader public to understand these decisions and what the implications are for them.
Yeah. So is it the case, and any of you can choose to answer these questions, but is it the case that what has occurred is essentially anti-avoidance provisions have been used now as a tool for, in fact, collection by revenue rather than being an anti-avoidance provision?
I agree with that.
I think the anti-avoidance is not the reason that these cases have come to their conclusions. They've been using the contractor provisions or they've been using the employment agent provisions. They're not saying that these are anti-avoidance. And I think we have clear anti-avoidance rules in there to stop people doing the wrong thing. So what these cases are actually finding is that people that are genuine, independent contractors are still being pulled within the Payroll Tax Act, not because of anti-avoidance, though.
I would say that it is important to have anti-avoidance provisions that deal with those relatively few cases that deliberately are doing the wrong thing, but these provisions are bringing in scope arrangements that were never meant to be within scope. So in a way, that could generate more revenue, but it's not appropriate within the policy intent. And so if the question of we need to generate more revenue is probably outside the scope of the terms of this inquiry, but there are other ways to look at that, to do that in an equitable.
So have other jurisdictions addressed this issue?
My understanding is that other jurisdictions are waiting to see what happens in New South Wales. And that's been the feedback that we've received from the commissioner into other commissioners in other states. And I think there's a bit of a vacuum of leadership in that respect. People are waiting and watching to see what happens. Now, whether it's fortunate or not that New South Wales is the first one out of the ring is a matter to be determined, but I think it's an exciting opportunity for New South Wales to show the rest of this country that this issue needs to be addressed and to address it in an equitable and appropriate manner.
I do think it's worth noting that Western Australia does not have contractor provisions. So
Yep.
Western Australia does have anti-avoidance provisions, which we all agree are necessary and should be there. But in terms of harmonisation, this is one area that there is not harmonisation nationally, and Western Australia does not have the contractor provisions.
So can you take us through some of the recommendations which you've made? Can I start with you first, Ms. Abdallah, and your recommendations?
Yes, of course.
The first of the recommendations, I think, is just a general recommendation to rewrite the Act. Is that a correct summary of it?
Yes, I think there needs to be some legislative amendments, and it can be done in a few different ways. It doesn't need to be overcomplicated. You can start with either dealing with the operative provisions on its own, or dealing with the exemptions, if we're looking at just the contractor provisions for now, or a combination of both. And depending on which way you go, ultimately they're all directed to the same purpose. So ensuring that the rules are applied in the right cases. They're targeted to the right kinds of arrangements, and they don't capture the ones that are never meant to be captured.
So, in terms of the rewrite of the Act, you'd start from a premise, would you, about saying what is included, or would you provide a system which in fact provides exemptions?
I would suggest that a more targeted operative provision, or a more targeted anti-avoidance provision that is limited and clearly brings within scope only those arrangements that are egregious for the purposes of what the provisions are directed to, that would be the starting point. We have currently a sort of expansive everything's in, but there are some exclusions. So,
and that's the problem, is it?
That's
is
right.
that everything is in, and then there are some,
That's right.
and if you don't fit within an exclusion.
Yes, and the courts have recognised that even some bona fide independent contractors are within scope, but they don't fit one of the exemptions for whatever reason.
Mr. Aquilina, have you got
Look, I sympathise with the difficulty of writing legislation. I've worked for judges as an associate. I know how hard it is on the other side to interpret these things. So as much as I'd love to scrap the tax system and start again, I don't think that's going to happen. We've made some very practical recommendations in our submission where there's minimalist change to the provisions to better target them towards excluding the types of arrangements we say shouldn't be in, that is the genuine independent bona fide relationships. And that's simply by moving away from a services test and integrating and using an integration and control test, which is aligning the law with basically 150 years of precedent around how we assess multifactorial relationships, around employment relationships. And look, it might not be, there might be better options in terms of how you might draft it. You might not use my drafting. I'm not a parliamentary draftsperson, but it's there. It's a solution, and it's a mechanism I think would be a quick and appropriate fix.
one of the tools that Revenue often uses, of course, is placing worked examples on their website to demonstrate who may or may not be caught. Do they in fact use that process in relation to payroll tax?
Of course they do. Of course they do. But the problem that we have with this, my experience at least, suggests that, and I tell this to my students because I lecture, be careful what the Commissioner writes down, because as well-intentioned as it is, it's only his opinion. I mean, the Commissioner's first amongst equals when you get into the courtroom, but ultimately I find that the Commissioner takes a very adaptive or flexible approach to the examples, and sometimes the examples are very hard to write. You've got to remember these are very broad provisions that capture potentially an innumerable number of arrangements, and if you're trying to write a number select examples, you're automatically setting yourself up to fail because it's difficult to capture the types of arrangements that might be in or out. There's nuance. Every case turns on its own facts, and the facts are granular, and it's the granular differences that make the difference. So yes, he writes examples, they're helpful, and I'm sure they've been very helpful to my colleagues as well, but ultimately they're never perfect, and they're very hard to rely on, particularly in a disputes context where it gets down to brass tacks. It's all about the interpretation of the raw provisions, which is what we're here to discuss as well.
One of the complaints that are replete through the submissions which have been made is taxpayers who have been the subject of an audit and had their businesses given a so-called clean bill of health, and 12 months later or 18 months later then have a further visit and receive a bill for exactly the same structure which they were using at a previous on a previous opportunity. Do you have any reflections about how that situation, given your observation, Ms. Abdallah, that you wouldn't be, you don't think amnesties are necessarily the way to go?
Just on the amnesties, I mean, they're obviously a step in the right direction, but They are not consistent across all the states in terms of who's within scope or who's not, and the periods to which they apply, but they're also not long-term solutions. And coming back to the guidance from the Revenue, so I think New South Wales is the only state where I think the Commissioner publishes Commissioner practice notes, and they're very useful. And the Revenue New South Wales does consult with the Tax Institute and other stakeholders on their guidance and on new law, and that's a very positive process. But there are times where the guidance hasn't been updated since a case or a decision has been made, or there could be further guidance that might be useful. And so the consultation is great, but there could be more of that which would be helpful. The examples, no matter how great they are no replacement for the law. And so the Commissioner's views, right or wrong, are no replacement for what the law says.
So what do you say about retrospective assessments?
Retrospective assessments, and the Tax Institute has spoken about retrospective amendments to the law at a federal level as well. It should really be only limited to very exceptional circumstances. I would say that it takes away from certainty that taxpayers have. And in cases like this, where we're going back many years, this can completely collapse a business in terms of the liabilities that were never accounted for, interest, penalties, things like that.
There was a recent case relating to penalties, though, wasn't there? Someone's submission made reference to the fact that a judge was very critical of penalties imposed where it was a retrospective assessment.
Excel
Retail
had penalties,
yeah,
and they were wound back as well. But that was a case where they were what would have been seen to be compliant, and then trolley management came down, and then off the back of trolley management, they were no longer seen. That they were then captured within the employment agency rules from that point, and so, and that's an example where the ruling on the examples on the Revenue New South Wales website still refer back to the UNSW global findings, and so they haven't been updated based on the trolley management case. And so you can see how Excel Retail, if they're reading all the information available to them on the Revenue website, they're making decisions based on what would have been the findings under UNSW Global, as opposed to...
And then to impose a penalty on top.
Correct, yeah.
Would appear to me to be something that a taxpayer who sought to be following the law found themselves
would have been difficult to understand.
In a very difficult circumstance,
yeah,
because what they thought was the correct interpretation of the law, because of a decision, found themselves not acting in accordance with the law. So what recommendation would you make in relation to that sort of circumstance?
So our broad recommendations around the employment agency provisions, which I mentioned earlier, there is actually a national standard for the Australian Bureau of Statistics uses, conjunction with Australia and New Zealand. And it's a standard industry classification. Revenue New South Wales already uses this information and pre-fills on a payroll tax return what business and what classification each business is in. There is a specific classification for labour hire services. And if a business falls within that standard classification that the ABS uses, then they're in for the employment agency agreements for payroll tax purposes. If you're in a different industry, you're not captured. It would be a very black and white, very easy to understand. It's a standard classification that would provide absolute certainty in this regard.
Why haven't the courts given us that concern? In fact, it's part of your submission, Mr. Aquilina, is that you can either have the Parliament give certainty or you can have the courts give certainty. Why haven't the courts given certainty?
Well, look, I think the courts are doing the best they can in a difficult position. It all comes down to the original source of the law, that is the provisions. And the provisions, in terms of this amnesty stuff, I agree that we should have relief, and I think industry would support that, but the best way to draw the line in the sand is to change the law. We can clarify it, we can do it, Parliament can do it, and we can do it in a way that will make the court's job easier. The courts are dealing with, if you've read the provisions, even the Minister or the Treasurer in Victoria who passed the original version of this said they are awfully drafted provisions, they're difficult on purpose. and they're going to lead to ambiguities. If you're a judge trying to apply a very complex set of facts in a very complex arrangement to these very broad and poorly drafted provisions, you can only provide so much clarity. But remember, courts' jobs are to determine controversies, so particular cases based on particular facts. And the problem is when the policy misaligns, there's no amount of clarity a court can provide to fix the policy. The policy has to be fixed by Parliament.
Thank you, Mr. Ackland. I'll just turn to some questions from the government, mindful of time.
Thank you very much for your...
You're right, mate. I'll go back to you. They've got a couple.
For your appearance and your submissions, and I concur with Mr. Tudor. Hope they were extremely helpful in covering off, particularly on the main cases, etc. I've just got a few follow-up questions from, I guess, this line of discussion. So it seems like there's interpretive issues. Not being a lawyer, but it seems I'm picking up there are interpretive issues. But these aren't new, are they? In that the Act is not new. These provisions aren't new. Indeed, the cases that you cite, I think, from memory, they start ramping up since about 2015. Is that correct? So these are well-known issues. I'm going to ask you to answer just for answer.
They're well-known issues, yes.
Yeah. And so across that period of time, I guess has something changed? And what opportunities have there been across that time? Where else have you spoken about this? What's happened in that intervening time to the people that you represent or deal with? Why haven't we heard about this in other forums?
If I may, I think the law hasn't changed, as you said, but the administration has. And I don't want to speculate. There's all sorts of economic and political conditions that lead to that, but that's clearly the fact.
But that's over at least a decade.
Oh, absolutely.
Right.
But yeah, the law is a slow instrument. Unfortunately, the wheels of justice turn slowly. So sometimes we're dealing with cases. Well, I think the loan market case was dealing with arrangements from about 6 years ago. So it takes a bit of catch up. So the administration of the law has changed. And I think people have been talking about this issue for a long time. But Dr. Kane, I think one of the big issues that we've seen is that the advent of, and you've written about this is the advent of the gig economy and around changes in technology. I think they're showing greater prevalence now economically than they've ever been. I mean, some of these, think about it, Uber was only been around for like 15 years or something. It's a rapid change in a short amount of time. So I think that the nature of the impact economically on these businesses and their contractors has really brought this to a crescendo. And I think people have been talking, I've been talking about it, I know my colleagues here have been talking about it, but you can talk into the wind sometimes. I think this is a great opportunity now for the Parliament to talk about it, and not only just talk about it, but to action and make change.
So perhaps there weren't formal opportunities to provide that into the...
Well, we provide feedback to the Revenue all the time.
Right.
But, you know, he'll be surprised to hear this, or the Revenue would be, I sympathise with them because they've got a job to do. Mm-hmm. And they're not law reform people. You know, you write academic papers, as you know, they get published. Do the people read them? I think they do. I hope they do. But
we track whether they do.
We try, you know. But ultimately, everyone's been banging on this drum for a little while. But I think this has been the first real opportunity to actually talk about how we might fix it from a legislative point of view, and New South Wales can lead the way.
Thank you. Were there any sort of responses?
I would say from the Tax Institute's perspective, this is something that we have spoken about. But we look at all of the taxes across the states and the federal level. And so a few years ago, we wrote a discussion paper called The Case for Change, and that looked at the whole of system and what needs to change. And payroll tax is one of the areas that we looked into as well. Around all of these cases, we write articles and we produce guidance for our members and the public about what these mean. As I mentioned earlier, we do consult with the Revenue and they talk to us about different provisions and their guidance and things like that. So there has been a lot of work going on, at least in the background, on these measures, but it seems to be coming to a head more so, which is really positive to see.
Yeah. I think I'd add, the way the rules are drafted, as we've said, is that everything's in unless an exemption applies. Yep. And 15, 20 years ago, we knew what all the possibilities in that world were. We knew how contractor arrangements looked. We've obviously had a significant change in the gig economy and how contracting arrangements worked, and then COVID happened. All of a sudden, everyone's working differently, and all the relationships and the arrangements are completely differently. So when we're in a world where everything's in unless it's out, when the rules were written before we knew what we wanted out because they didn't exist, it now puts us in a position that we don't have the exemptions that we need to apply to the current environment, as opposed to if we had a system that said these are the things that are in, then when new arrangements were found, then there could be changes made to bring in new arrangements as they needed to be, but because we're in that default of you're in unless you're out, as soon as anything new is created, it's automatically going to be caught.
Just a couple of questions, and you've mentioned the gig economy, which, as you know, Mr. Aquilina, I'm particularly interested in. It sometimes sounds as if, and sometimes in the submissions, it sounds as if it's the contractor or the gig worker who is liable for payroll tax, and clearly it's not. It's the platform, etc. So there's a couple of questions that I want to ask about that. One is, have you got examples of where, say there's been this retrospective liability and you've seen that flow through the contract chain? So that's one question. And I guess the other question, which we might go to after, and maybe directly to Mr. Aquilina, because he's been speaking directly about gig work, is not all platforms are created equal. And you talk about the multifactorial tests in other areas, and they're not exactly matching in other parts of the law either. But some of the platforms have been extremely creative about, clever contracts, amending contracts, etc. So isn't that going to be a continuing issue if we're not very careful in what we do to capture the right players? So there's the examples, if you've got examples of where it has flowed down following a decision, and the other is, they're not all equal, are they?
So just on the first question, I've definitely seen this so when loan market was decided, the first thing that the aggregators did was look at their arrangements, and this is public knowledge. They've released addendums to change the arrangements to push down the costs, because remember, they're intermediaries. They're operating themselves on a 5% margin. The payroll tax is the margin plus something else that's got to go somewhere. And the problem with, and I agree, I have full sympathy with you around these big players playing an important role in determining what work looks like these days and how that can be exploited. But in specifically the tax context, Dr. Kane, what we're talking about here is an embedded cost in delivering services through a supply chain that gets pushed down to someone. And either consumers will pay or the businesses will pay in the supply chain. It's usually the most vulnerable in the supply chain that gets stuck with the bill. And that's what's happening here. The tax has an adverse impact on small enterprises, who are typically the types of people I think that you would suggest in your paper that you published. That these are the former employees that were working for these types of businesses. They're the ones being punished here. So technically, yes, the assessment of the tax is on the big entity. But economically, Dr. Kane, this flows through the system. And that's a huge problem.
What have you got a suggestion? I mean, it is, you're absolutely right.
Yes.
I'm not quibbling with you about that.
Yes.
And about the nature of business arrangements will end up at the bottom of the supply chain bearing the brunt. Gotcha. Have you got any, have you got any suggestions in this area of law as to what might assist with that?
Let's not tax them. These arrangements were never meant to be caught. Let's not tax these people. That's the problem. The problem is we're embedding a cost. And it doesn't serve workers' rights or serve their ability to be protected or to have decent standards by having a system that encourages economically the costs to be pushed down the supply chain onto them. The problem is none of these arrangements were intended to be captured in the first place, right? So unless we're starting from the proposition that these contractor arrangements where the contractors in the supply chain were always meant to be caught, I don't accept that personally. But the problem we have is that they are bearing the economic cost. The cost is unjustified principally based on the objectives of the provision. And the solution, I think, isn't going to be to create a system that puts that embedded cost down to them. It's going to happen. I'm not sure what Parliament could do to prevent that from happening, because it's the nature of business. You put a tax on a supplier or a service, someone has to bear the cost. My concern is that the current system is designed is incentivising directly the most vulnerable of those businesses to bear that cost, and that's what's really concerning.
So the issue is actually with the employment, the business structure, creating a particular employment relationship, really, isn't it? It's not about the tax, it's about the employment.
Well, in the employment context, there are many things that Parliament could do to protect the rights of these people and ensure they have good standards, whilst at the same time not taxing them.
Interesting. I mean, I'd love to chat with you on another time about that, Mr. Aquilina. Any comments from...
Look, I'd just give examples of a colleague of mine that was at a GP last week and paid the bill and then noticed that there was an extra $5 on the charge and it wasn't even part of the invoice. Called them up and said, why did it hit my credit card at an extra $5? And the answer was, that's the payroll tax we have to pay. I have, other clients that are making assessments and where they have a medical practice that's not doesn't meet the bulk billing, they're just charging it straight onto the clients. There's no, as mentioned, there's no sense that that margin will be absorbed. It'll just be passed on to people attending those medical practices.
Interesting.
Mr. Tudor, Dr. Kane, have you got more, or Mr. Tudor?
No, I'm good for now. Thank you.
Yeah,
Thank you,
go.
Mr. Tudor. No, thank you, Mr. Tudor. Okay.
I think in summary, in answer to Dr. Kane's questions, is that this problem, albeit starting in 2015, probably is reflective of the fact that the nature of work has changed.
Correct.
And would you agree with this proposition that because of, whether you call it aggressive or not, because of the collection of this payroll tax, this represents in one sense windfall gains to revenue? Is that correct?
Without using that phrasing, I'd suggest that it's broadening the base of which payroll tax is being applied. I think also I would say that there are a number of businesses that still aren't sure how payroll tax applies, and if we were to take, so the GP scenario, that's been discussed widely, it's in the media and everyone's sort of across all of those cases. But if we were to look at similar structures for a physio, a dentist, mental health professional, any of those other industries, I suspect...
Lots of them have never paid tax before, will all of a sudden find themselves potentially liable to pay tax.
But so I would put it to that there's no revenue currently being collected from them.
Yeah,
so a change in that would not negatively impact any of the revenue that's going to be collected. And so it could be rectified without any, well, it could be rectified without there being any impact.
Any impact on the
Correct.
existing revenue.
Yeah, exactly.
Yes.
Thank you.
No more? All right, well, thank you very much. That concludes the questions. I don't think there are any questions taken on notice. There was a couple there taken on... There was a couple taken on notice. So the Secretariat will be in contact in due course.
Just can I ask one?
Yeah, certainly, Mr. Chair.
Have you all read the Chief Commissioner's submission?
Yes.
Have you got any observations in relation to anything that the Chief Commissioner has raised?
I think the Chief Commissioner was appropriate in his position in the sense that he educated taxpayers on what the current law is and how he's administering it, and didn't go beyond that remit. I think that's probably the right approach.
I would agree with that sentiment. He's not in a position to comment on the policy. He's focused on the administration. He's made comments about the approach that they've taken, which I think are fair from their perspective.
Sitting here today, is there something that we could do in terms of a parliamentary position, is to have an amnesty in relation to this until such time as this eminent committee makes its findings, and the Parliament no doubt will act on them for the purposes. Is it your position that we should be having an amnesty while this issue is resolved?
We would support an appropriately drafted amnesty, yes. Or I would. I say we, I speak for Dentons Australia.
I would agree with that approach. If I could just summarise, we need legislative amendments, we need consultation on those changes, updates to the guidance, and a temporary approach in the meantime until we can achieve those.
I take it you're the same, Ms. Bix.
Yep.
Thank you.
Well, thank you very much for your submissions, your excellent submissions, for your evidence today. We very much appreciate it. And as I was in the process of saying, the Secretariat will be in contact in due course with those questions and those matters taken on notice. Thank you very much. You're dismissed.
Thank you so much.
Thank you.
Well, good morning. Welcome to you all. My name is Jeremy Buckingham. I'm the chair of this committee. Welcome to the hearings into the Payroll Tax Act inquiry. Before we commence, if I could get all of you to state your name, your position title, and swear either the oath or the affirmation. And we'll start on my left with Dr. Raphael.
Dr. Sarah Raphael, Director of Policy and Education for the Australian Dental Industry Association. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you, Doctor. Mr. Burns.
John Burns, CEO of Urbano Healthcare. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much, Ms. Egan.
My name is Dominique Egan. I'm the Director of Workplace Relations and In-House Legal Counsel at AMA New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. And Dr. Hoffman.
Dr. Rebecca Hoffman, I'm the RECGP New South Wales ACT Faculty Chair, and I'm a general practitioner. And I'll do an affirmation. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. The committee now affords you the opportunity to make some introductory remarks. We'll start with Dr. Raphael.
Thank you. Chair and members of the committee, thank you for the opportunity to appear before you today. Mr. John Burns and I represent the Australian Dental Industry Association and the Dental Service Business Council, that's not going to work, which together represent a significant portion of Australia's dental service providers. These dental service organisations operate more than 400 dental clinics and support over 2,500 clinicians and additional employed auxiliary staff nationwide. We believe the application of the contractor provisions under Division 7 of Part 3 of the Payroll Tax Act 2007 poses a serious further threat to the affordability of dental services for New South Wales families. The imposition of payroll tax on independent contractor arrangements, both retrospectively and moving forward, will place an overwhelming financial burden on operators, many of whom already pay payroll tax on their employees' wages. Without an amnesty from historical liabilities, we estimate that for clinics with 3 or more dentists, these additional costs may drive up patient fees or even prompt clinic closures. We are particularly concerned about the potential for closures in regional and rural areas where access to dental services are already limited. Like general practitioners, our colleagues here, the largest costs for dental service organisations are the expenses of the health professionals, the talented dentists who provide essential dental care. Like general practitioners, imposing payroll tax on dentists most likely ends up with consumers meeting the costs through increased patient fees, and we've just heard an example of that. The likely consequences are troubling. We know many Australians are already delaying dental care as they grapple with the rising cost of living. Preventable conditions will therefore escalate, leading to increased hospital admissions and a greater strain on our already overburdened GP services and the public health system. In New South Wales alone, there were over 24,000 preventable hospital admissions for dental conditions in the 2022-2023 year. We therefore urge the government to amend the Act so that the genuine independent contractor arrangements, such as those between dental practitioners and clinic operators, are not subject to payroll tax. Most importantly, we seek a New South Wales Government amnesty on the imposition of retrospective payroll tax liabilities, given the significant legal uncertainty to date. Without these changes, the viability of dental clinics and patient access to essential care will be severely compromised. In Queensland, a bipartisan amnesty of retrospective payroll tax has provided certainty to dental clinic operators. We look forward to answering your questions later. Thank you.
Thank you. Do you have anything further to add, Mr. Burns?
No.
No, we'll now turn to the AMA. Ms. Egan.
Thank you. I'd like to begin by acknowledging the traditional owners and custodians of the land on which we meet today, the Gadigal people, and pay my respects to elders past and present. The AMA is an independent medical association that represents the medical profession, from specialists to general practitioners, doctors in training, and specialist practitioners in private practice. One of the AMA's principal objectives is to represent and advance the interests of medical professionals and patients through effective advocacy. Over the past 5 years, AMA New South Wales has worked closely with general practitioners in relation to the issue of payroll tax and its impact on private general practice following the optical superstore decision in Victoria in 2018. In 2020, the then AMA New South Wales President, Dr. Danielle McMullen, wrote to the New South Wales Treasurer raising concerns regarding the potential exposure to payroll tax for medical practitioners. AMA's New South Wales focus has been on the impact on general practitioners. They are less likely to be able to rely on the exemptions that exist under the payroll tax that may be available for non-GP specialists, namely the public service exemption and the 90-day exemption. And this is due to the differences in the way in which general practitioners and non-GP specialists work. Further, the margins in general practice are much tighter, and so there is less ability to absorb those costs. In 2024, the New South Wales Government announced and legislated 2 initiatives for general practitioners to supplement the existing exemptions under the Act for those who were able to take advantage of those. The first was a legislated exemption for any unpaid payroll tax payable on wages paid or payable to GP contractors prior to 4 September 2024. The second was a legislated payroll tax rebate on wages paid or payable to GP contractors on or after 4 September 2024, provided the applicable bulk billing threshold is met. Since that time, the Queensland Government, and since the time of our submission also, the Queensland Government has legislated an exemption for all wages paid to general practitioners, and that includes contractor payments. AMA New South Wales calls on the New South Wales Government to replicate this arrangement so that we don't have a situation where we lose general practitioners and practices across the border, particularly in northern New South Wales, and also to create a position of certainty, as while we acknowledge the exemptions that have been legislated in New South Wales, there is still much angst and uncertainty amongst general practices about how that applies to them, particularly in relation to the application of the bulk billing threshold. Happy to answer the committee's questions.
Thank you, Ms Egan. Dr Hoffman.
Thank you. I'd like to thank the committee for the opportunity to give evidence today. The RACGP, who I'm here representing, is Australia's largest professional general practice organisation. We represent more than 50,000 members and more than 15,000 in New South Wales. For over 60 years, the RACGP supported Australia's healthcare systems and set the standards for education and practice, and advocating for better health for the well-beings of Australians. I'm also here, though, as a GP and as a practice owner as well. In August 2023, as we've heard, the New South Wales State Revenue Office issued a ruling to broaden the application of payroll tax, and that was to include independent general practitioners. The applications of this ruling threatened the viability of the general practice system in New South Wales and definitely impacted patient care and patient access to care. In June 2024, the New South Wales Government announced limited exemptions for independent GPs, meeting set bulk billing thresholds, and later announced exemptions for independent GPs from earnings derived from the DVA rebates, so that's the Department of Veteran Affairs rebates. There's still work to be done to ensure that GPs can continue to provide vital care to their communities now and into the future. The hearing today represents an opportunity to discuss the applications of the Payroll Tax Act within the framework of healthcare models and to support the viability of the general practice sector. I look forward to answering your questions.
Thank you, Dr Hoffman. Some questions now from the opposition. Mr Tudor.
Can I first, rather, in case I'm going to be accused of a conflict of interest later on, my wife was a dentist. Can I just ask this to start with? What is the model that dentists use which brings them within? Describe just how that model works so that revenue can construe that they fall within the ambit of an employee for the purposes of the Payroll Tax Act.
Absolutely. And also just to clarify, so I've been working in predominantly general practice and then dental for the last 20 years. So there's quite a lot of equivalencies across the two. So in dental, we have a FASA, or a Facilities Service Agreement. Effectively, in the majority of cases, the dentist, we will we will obviously collect billings on behalf of the dentist. We'll remit 40% of billings to the dentist. We share lab costs on a 40-60 split. We pay payroll tax on all of our employees, which includes practice managers, receptionists, and dental assistants, and any other additional staff that we might have on site or in our support structure. The provision of the payment of payroll tax for us would represent approximately $5 to $10 per consultation of additional fees, and a loss of margin of around 2.5% for us as a business. For the majority of non-corporate practices that are smaller, they will sit under the threshold, and obviously it's not a massive issue for them. But once you get to 3 dentists or more, you are definitely within the payroll tax capture. And so for us, we have not traditionally paid payroll tax. Both in GP and in dentist over the last 20 years, and certainly the last 30 years, there's been a movement away from solo practice. It's better for patient journey, better for patient access. It matches our practitioner patterns. They want to work part-time, they want to work in a group environment so they can take leave, etc. In the case of dental, they can share quite expensive scanning equipment, etc. So the forming of group practice over the last 30 years, whether it be privately owned or corporate owned, has been a significant shift. Smaller practices under the threshold, those that are in group practice under a payroll tax payable situation would have that serious imposition, which we haven't had to date.
And this applies across the board to general practitioners as well. Is it the fact that the primary problem is that the is that the structure which has been organised is a group practice? The so-called employer collects all the fees which are payable and then distributes those fees to the practitioner who has in fact been involved. Is there a solution from your perspective that the practitioner actually collects their own fees?
Yeah, the flow of funds is a very interesting concept, which I think has been, certainly from our perspective, has been considered and remains a consideration. Up until this time, the collection of funds and the remitting of payments has been part of the service that we've provided. I very much see general practice and dental clinics as being individual independent contractor. It's not wanting to run a solo practice, looking for group practice, but they're running a business within a business. They're running their business within our business, and that's very much the basis of the model and why payroll tax and employment-like definitions are problematic. But the collection of fees has always been a service that we provide. There's a machine at the desk, it's an FPOS machine. In the case of dental, there is an insurance payment that needs to be considered as well. And so pushing that flow of funds to a dentist, receiving the funds and then remitting to us would be problematic.
Well,
but not impossible.
Is it the same position that applies in relation to GPs?
It's a very similar position. There's a few different models of general practice. There is a similar where you're an independent contractor working at a group practice, and the practice does have a very similar machine at the front desk where they take payments and then the Medicare rebate goes back into the patient's account. Or if they are bulk billing, then they accept the Medicare payment instead of charging the patient. There are some newer models where GPs are salaried employees and they are entirely and appropriately paying payroll tax. But very similarly, GPs already pay payroll tax for their registrars, for our nurses, for our admin, for all of our employed staff. It's the GPs, the independent doctors, that up until last year that they weren't.
Well, see, I had some personal experience. I went to see a skin cancer person, and depending on who you saw, each of them had their own individual terminal.
Yeah.
Would that have solved the problem?
Well, it could have, but I've got 24 doctors. I have no interest in having 24 terminals at my reception. They're not going to have... all of my doctors are part-time. They're mums with kids. They work a day and a half a week. The admin burden on that is phenomenal.
So the admin burden would almost equal the payroll tax
absolutely
impost, which would be imposed. So it would effectively be passed on to the consumer at some stage. Is that the same with?
Yeah, very much.
Are there 24 dentist practices?
No, GP practice, group practice tends to be slightly more GPs on average. But to Rebecca's point, you don't really want a dentist who is a mum on a Sunday sitting at all her looking at her billings for the last 2 weeks and trying to work out how much she's got to pay for Urbano's service. So it's sort of, for us, it's part of the service that we say we'll collect, we'll give you a full statement, and then we'll remit your funds every 2 weeks. And that's just a standard practice. And again, I see it as part of the service we provide to independent contractors.
Mr. Tudor, could I just ask one that's related? Sorry, just so that I understand. So, and probably to all of you. So, you're providing a service with regards to the kind of the admin and the collation and the flow of funds, etc. Back office stuff. Is that separate to, in the GP area, is that separate to, when you say group practice, is that a separate service to say if you're, for want of a better term, part of a branded chain? Is that a different thing? Is this a service that's kind of back of the office that we wouldn't know about, or is it we have a brand and that provides all of that service? Because for me, there's also a difference in sort of a branding of chains of things and what might be a service in-house that no one sees, because there's no goodwill attached to that.
Yeah, it's interesting. I always draw a triangle, which is the operator, ourselves, the dentist or GP, and the patient. And for me, our primary relationship is between us and the dentist, and the other primary relationship in that triangle is between the dentist and the patient. The relationship between us and the operator and the patient is not a primary relationship, and brand comes into that, but that is simply what's over the door. The people will come to see the dentist or the GP, and that's why I say they're operating a business within a business. They build their own brand. If they leave, then the patient will follow. So for me, the link or the brand, the retailness of a brand doesn't translate on that axis between operator and patient. It's not a strong relationship as the other two. And I think that's very important. Our customer is the dentist, and their customer is the patient. That's very, very much how we structure our business.
Exactly the same in general practice, is that patients have their doctor. The practice is where their doctor is, but the patients have their doctor that they go and see. And yes, they'll see somebody else if their doctor's not available that day, but they'll still want to go back to their doctor, to their GP. The service fee also doesn't just cover the funds, it also covers the admin fees, and it covers the nursing fees, and it covers the mortgage and the electricity and all of the other costs that come with running a business as well. So it's all of that is part of the branding and the service fee, but the patient who comes to see you, they absolutely are coming for that independent doctor.
So what's the value of, why do you need to then have a brand? Like, why then isn't it just, this is the doctor's surgery on Macquarie Street, I don't need to name a particular. What then is that about? Why do you need that?
That's a fascinating question. I see the value again in that the relationship between the practitioner and the patient. And for me, brand or the retailness around a health environment is very secondary, and for me actually holds very little value. I may get in trouble for saying that because I run a branded business, but it is a pure service GP dentist to patient relationship.
Well, just got to say in relation to that, isn't there a benefit being in a multidisciplinary practice, being in terms of all the technology which is potentially available and made available to those dentists who operate in the practice?
We have a CPCT costs about $150,000. It is a live CT. It allows guided placement of an implant, for example, in the mouth. It is an expensive piece of machinery, and particularly young dentists are looking for that level of support, and a lot of established dentists as well. And a lot of our the money that we do get from a margin perspective, we're a very capital intensive business, and it's about reinvesting, because I'm dental phobic, ironically running a dental business.
I love the dentist.
I do not. But my last experience was a dental implant. It was guided through a CPCT. It was an exceptionally good patient journey for me and patient experience. And so that's why, again, group practice allows
I
access.
guess for me, my question is less, I completely understand the economies of scale and all of that. That makes complete sense. It's more, I'm still struggling with the value, if from what you're saying, the relationship that you're focused on is the patient doctor or dentist. Then I'm still struggling a bit with, because there's a lot of branding out there. So yes, the economies of scale, yes, the service is in the same place, I understand, but I'm still figuring out then, there's got to be some value. There's a business model there which is about branding, and I
think
can't.
you'll find that branding even in small solo practices and like practices with 2 or 3 dentists now. They will call their practice something, Happy Smile, like that's not a good one because that is a corporate.
That's kind of
They'll
captures
call it,
the thing, I get what you're saying.
Bright Smile, or, it's just become a thing that has, for identification, I think, with consumers. I think they want a name. That concept of having the brass plaque with Dr. X on it now is, even though when they get in there, they want to see that particular dentist or doctor, they want, I think it's just consumerism. They want a...
But that goes to whether there is goodwill in a name. That's what I'm getting to. So I'm just, genuine questions. I'm just trying to...
The thing with group practice is, again, that axis between operator and patient. You want to be open, good opening hours. You want to have patient access. You want the site to be clean. You want it to have a good reputation. And the minute you come away from that solo practice with the plaque on the door into group practice, then you have to call it something. And then you might call that something another one that's 2 suburbs away. And so, but generally for me, general practice and dentists, they are local businesses. And dentists will join a practice, as will GPs, not necessarily because of the name above the door, but the person that's practicing in the room next to them and the room next to them. It's about who is in that group practice. Is the medicine good? Yeah. Does it have a good sterilisation compliance? Do they have good nursing ratios? Do they have a great PM? So they're much more important than what's above the door.
I think as well, sorry, if I could just add one thing to that. I think as well, the group practice model as well has been very much become a feature because that is what regulators expect. They don't want people to be practicing on their own because that's not good necessarily for that practitioner because they're isolated. And then for the patient, when that practitioner tries to take leave, then they don't have continuity of care. So while I think, as Rebecca's point was, people very much associate with a person as their general practitioner, what they actually also want is to also know that there's somebody else to care for them if their practitioner is not available for one reason or another. And that is also the advantage of the brand, to know that they're going to a practice where they have a good reputation in that regard.
Thank you. I'm sure it's there's a multitude of different circumstances. With the group practice, is it that the practitioners come together and then move in collectively under an umbrella of a brand, or are they recruited in individually, or how does it usually work? Is it that the overarching business just brings in individuals, or is it that the practitioners get together as a collective and then move in underneath a brand?
I think a lot of people now are joining established practices, and a lot of that, they establish those connections when they're training, and then they're invited to come into the practice once they've gained fellowship. Probably some of the bigger corporate practices do have a recruitment model, but I think most people now are joining established practices, but there may be 2 or 3 practitioners who get together to decide to establish a new practice together to share the overhead.
It's also a really well-established registrar model as well. If you're a training practice, we have the same in dental, and you get really good talent coming in as a registrar, and you provide them with an environment which is conducive to chronic disease management, etc. Then they will then graduate in. Both sectors, as well as other sectors like veterinary, the traditional model of the senior owner bringing in a junior, and there was 2 people in the practice and they retired and handed the practice over, that ceased to function about 30 years ago. And so in its place is collectives, I call them collectives, of doctors wanting to work together. And that's how I explain to a lot of GPs coming out of solo practice to join a group practice. Your business within our business, it is a collective. You have a shared voice on how you wish us to help you run your practice individually and collectively.
Dr. Kane, certainly.
So this is really fascinating, and I'm sorry if there seem to be obvious questions, but how many, if we were to sort of look at the sector overall, how many of the businesses would be sort of at the bigger end, and then how many would be that more traditional, which you say is not really the thing anymore, and regulations pushed to a different model? So and you can take it on notice and get back, but I'd be interested in sort of numbers of businesses that are at that bigger end, multiple operators, that collective model, and how many of that more traditional breakdown. And I guess a related question would be, how many dentists or doctors would you need in a practice to get over the threshold, the 1.2 million threshold?
Because there's really three categories, which we can certainly come back with some detail.
That'd be great.
Which is three categories. The first one being 1 or 2 dentists will be under the threshold regardless of who's in scope for payroll tax. Those that are currently out of scope based on non-contractor costs, that would be in scope if you add in the independent contractor revenue, and then those that are already in scope if we apply the rule because they're already paying payroll tax and they're above the threshold for non-contracted employees like nurses, dental assistants, PMs. So there would be the three categories.
Okay. And you can provide some more.
Practice managers is PMs.
Oh, sorry, practice managers, PMs, very important
Admin.
people.
Yeah.
Thank you.
And
We do have a little bit of the answer to that question. So in Australia, the dental service organisations that we're representing today run 403 clinics across Australia and 2,502 clinicians. So that's averaging out to about 6 is kind of that average number where that's sitting just over 6, I guess, per practice. And that is much more common, for example, than GP practices that perhaps have the larger numbers that Dr. Hoffman was talking about.
Sorry, someone over here with...
No, with general practice, it's closer to 4 FTE until they're meeting the threshold.
Yep.
4 FTE to meet that threshold.
For us, it would be, I think, 3 FTE, yeah.
Okay. Thank you very much. Thank you.
Just in terms of the general practitioners effectively now have a new regime they operate on. Since that has come into place, have there been any further audits in relation to medical practices?
There has.
To your knowledge?
There has. There's now practices that are paying payroll tax. There are now practices that will be eligible for the rebate if they've met the bulk billing thresholds for payroll tax. And as we've heard before, there are practices that are now passing on that payroll tax to their patients.
And in relation to that, the number of practices that are now paying payroll tax that weren't previously? Have you
I'm happy to take that on note.
Notice in terms of in relation to your can I ask the dentists the same thing? Sure. How many dentists are currently the subject of audits? Are you aware?
Across that?
No, we'd need to take that on notice.
Are you aware of any court cases involving dentists?
We're not aware of any
practices?
at the current time.
Not in New South Wales.
Where there has been a challenge to the payroll tax assessment?
We're not aware of that at this time.
Are you aware of any circumstances where dentists have been audited and been the subject of retrospective tax?
Yes, we are.
Do you have any data relating to how many have been audited and who would be the subject of retrospective tax?
We would have to take that on notice as well.
And similarly, general practitioners, are there any current challenges to payroll tax assessments that you're aware of?
Not that I'm aware of.
No, not that I'm aware of.
Are there, in terms of the actual audit process, are you aware of practitioners that have been audited and been found to be potentially liable for retrospective tax?
Only previously to the new legislation.
To the new legislation?
Yeah, and the same.
And there are cases involving them where retrospective assessments have been levy?
Prior to the amendments, yes.
Was that challenged?
No, the GPs I'm aware of have had to pay that.
Pay the retrospective tax?
Yes.
Is it the circumstance that Revenue, in fact, had previously given a clean bill of health to a practice and subsequently assessed that practice for the purposes of payroll tax, given the impact of Supreme Court decisions, but whether in Victoria or New South Wales?
Not to my knowledge, but I can take that on note as well.
Thank you.
I know that there were some that were being looked at. I'm not sure whether they went through a formal audit process yet, but there was some concern about that. But I can make some further inquiries.
But I think there is a sense of resolution across both sectors, that anybody who's been through the process and sort of come out pleased with the outcome. So I think
have generally been pleased with it?
No, have not been. No one's come out and been. That was fine. We came out unscathed. So it's just, I think, for us collectively, it's the uncertainty.
Dr. Kane?
Yes, please. Thank you. And just want to pick up on a couple of things. So, Ms. Egan, you spoke about, in your opening statement, you spoke about 2020 being, I'm assuming, quite a catalyst for concern and writing to the Treasurer about payroll tax liabilities and exposure to that. And then you jumped ahead to 2024. I wondered if you could speak a little bit about what happened in that time. And I guess maybe if the others on the panel also in that time, I suspect, probably had concerns that were triggered around about the same time. If you could speak about what happened in that period of time, that would assist me understanding the context.
Yeah, certainly. So we met with Revenue New South Wales about the optical superstore decision in early 2020, and then that prompted the initial correspondence to the then Treasurer. In that period of time, we made repeated representations to government about our concerns around payroll tax, and we engaged about, what an exemption might look like, or how that might be dealt with. Similarly, and in cooperation with the RACGP, we also participated in discussions that looked at, the statistics around general practice, how many general practitioners there were, what their fees were, and all of those arrangements.
Sorry, discussions with who?
That was with Revenue New South Wales. So we throughout that period, we were making representations and participating in consultation, and then the legislative amendment resulted in 2024.
Okay, so in that intervening period, so with the previous government, it was simply continued representation. What was the response? Was there a definitive response?
There wasn't interest at that time, as I understand it, in legislating an exemption for general practice.
And was that similar experience for did you have any?
We certainly, I was actually during that period, I was predominantly in general practice, not dental, so I've only been in dental for a year and a half. Sarah, do you have a perspective?
I think this is where some of the similarities are, well, it's where there aren't similarities, because obviously that legislation was directed at Medicare billed and government billed services, and because dentistry is 85% out in private, that hasn't been as applicable for us. So the whole time has been a period of uncertainty as far as past payroll tax liability. And I think everybody has been slowly monitoring what's happened in other jurisdictions to try and get a gauge on what we would believe would happen for dentistry in New South Wales.
So were there any meetings with relevant ministers, or it was always state? It was always
they were meeting with ministers as well.
They were meeting with ministers across different portfolios?
Yes.
Or,
yeah. So health, finance.
And not Treasury?
I can't recall.
Would you... would you take that on notice?
Yes.
And let us know what they mean? Thank you.
We didn't. We've only met with the health and finance ministers regularly, and with the state revenue office, we had a working party at one point where we were meeting almost fortnightly.
Oh, okay.
To really talk about mostly around the impact of the retrospective payroll tax liabilities, but also then what the legislated options would be.
Thank you.
And one of the issues, of course, which was raised was the requirement for harmonisation, and that whether a change in New South Wales, what would occur in relation to other jurisdictions, because I think New South Wales has obligations in relation to the harmonisation of its tax arrangements. I take it that the dentists would advocate for exactly the same provisions to be applied to the general practitioners in Queensland.
Absolutely.
Absolutely.
For us, the equivalency is we're talking about doctors and doctors.
Yep.
Just happen to be working different parts of the patient. And I know that then there is an argument around it, sort of the widening to allied health providers. I don't see the same equivalency.
And I take it you would encourage the New South Wales government to adopt the same across-the-board provision as been adopted in Queensland, rather than I suppose there is an administrative burden which attaches to assessing whether you fall within or without the 80% rule or
Yes.
the 70% rule.
And it varies from quarter to quarter. And
And that's right, and that of itself has an administrative burden attached to it, and for simplicity, you would be saying that this is something which just ought to apply across the board.
yes.
Absolutely, but not just in Wales, but nationally as well. There needs to be a nationally consistent model for payroll tax, not based on different jurisdictions. And the administrative burden is enormous. It's not just based on the Medicare, but there's work cover payments, there's insurance payments, there's DVA payments, clarity around which payments contribute to the bulk billing threshold and which don't, still unclear.
Yep.
Thank you, Dr. Hoffman. Done? Well, thank you all for your submissions. Thank you very much for your attendance here today to inform our inquiry and this hearing. We very much appreciate it. There are a couple of things taken on notice. The Secretariat will be in contact with you in due course for those. But thanks again very much. It's very much appreciated. You are dismissed. Thank you.
Thank you
Well,
so
colleagues, it's now time.
You're not dismissed. You're
much.
released.
Oh, yes, it is.
Released.
You're right.
You're sacked.
You're sacked.
You're free to go. Thank you, everyone. It is now time for morning tea, so we'll have a break and reconvene at 11:15 a.m. To our witnesses, welcome and thank you for taking the time today to give evidence. Before we commence, we need to get you to state your name and position title and swear either the oath or the affirmation, and we'll start with Mrs. Puxty on my left.
My name is Kim Puxty, CEO of the Building Service Contractors Association of Australia. I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Mr. Diamond.
Thank you, Chairman. My name is Mark Diamond. I'm the legal counsel for Quad Services, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Diamond. Mr. McCann.
Thanks, Chairman. Paul McCann, CEO of ARA Property Services. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And Mr. Walker.
Thank you, Chair. I'm the Managing Director of Mastercare Australasia, and I also solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Walker. I'd just like to inform everyone that the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I note that in accordance with these rules and with the prior agreement of the committee, the witness appearing for Mastercare, Mr. Colin Walker, today will have reasonable opportunity to consult his legal advisor during the hearing if needed. Do any of you have an opening statement you would like to give to the committee? Starting with you, Mrs. Puxty.
Yes, I do. Thank you, Chair. Good morning, honoured members of the committee. Thank you for the opportunity to address this inquiry into the Payroll Tax Act 2007. My name is Kim Puxty and I'm the Chief Executive Officer of the Building Service Contractors Association of Australia, also referred to as BISCA. Our association represents a diverse range of businesses within the cleaning and building services industry, which are integral to maintaining the health and safety of our community and workplace. The Payroll Tax Act, particularly its employment agency provisions, has had significant implications for our members. Initially, our members were confident in their compliance with the Act. However, through recent audits carried out by Revenue New South Wales, it has left them confused and seeking clarification on the employment agent provision. For example, members who were previously deemed compliant by Revenue New South Wales after previous audits have now been classified as employment agencies despite no changes in their business structure or practices. Guidance from accountants and Revenue New South Wales has not provided clear answers, causing significant operational and financial strain. Our industry relies heavily on contractor arrangements to meet client demands. However, the current legislative framework lacks clarity in its interpretation, leading to uncertainty and potential non-compliance. The BSC has made a formal submission to this inquiry, outlining the challenges faced by our members and proposing recommendations for more equitable tax policies. Our key recommendations are the complex and confusing rules. We are seeking that the current payroll tax rules that are considered difficult to understand and creating compliant challenges for small and medium-sized businesses be addressed. The retrospective taxation. The retrospective application of payroll tax means businesses have to pay taxes on past transactions that weren't previously taxed, leading to unexpected and often huge liabilities. We strongly recommend ceasing this practice immediately to give businesses time to realign their budgets, speak with their clients, and align their business to meet their legislative requirements. Lastly, education and communication. BSCAA is committed to working with the government and other stakeholders in improving and providing understanding and compliance. We would like to see educational resources and clear guidelines to help business navigate the complexities of the Payroll Tax Act. In conclusion, the BSCAA is dedicated to advocating for our members and ensuring their voices are heard. By participating in this inquiry, we aim to promote a fairer, more transparent and supportive regulatory environment. We believe in ceasing retrospective taxation, clarifying the employment agency provision, and enhancing education through collaboration with industry bodies to better support businesses. Thank you.
Thank you, Mrs. Puxty. Mr. Diamond.
Thank you, Chair. I've got a short opening submission to make. I'm here today on behalf of Quad Services. They're a significant business. We're seeking three things only: fairness, transparency and predictability in the application of the payroll tax legislation. That's why we're here. I think you would all be aware, members of the committee, that there is a significant amount of angst, certainly within the cleaning industry, about the way in which Revenue New South Wales is interpreting the employment agency provisions. Based on everything that we know to date, pretty much every cleaning contractor would be caught by the employment agency provisions. Now, that just cannot be right. It cannot be. Cleaning contractors, by and large, provide a comprehensive service. They bring equipment, yes, they bring labour, and they bring a number of things. They bring materials, they bring gear. That's not employment agency, can't be. What we hope from this committee is that we get some clarity and some fairness and some reasonableness in the application of these provisions. Quad doesn't come here asking for the law to be changed. That's not why we're here. But what we are here for is the interpretation and administration of that law to be changed. It needs to be. This is an extinction level event for a lot of small to medium-sized businesses. I'm not exaggerating when I say that. You have medium businesses getting bills for $7-8 million because of the retrospectivity provisions. Can't be right. I thank every member of this inquiry for giving us a chance to be heard on this, because it's that important. Thank you.
Thank you, Mr. Diamond. Mr. McCann.
Thank you, Chair. Good morning, honourable members. Thank you for the opportunity to present today. We believe the problem is this: payroll tax laws were designed to prevent avoidance. Today, they risk punishing compliance. I want to highlight a few themes from our submission, which I note were shared by many others. Firstly, harsh unintended consequences. The application of payroll tax, particularly the relevant contractor provisions, are outdated and harsh. Originally introduced in 1985 to prevent employment relationships disguised as independent contracting, they have failed to evolve with modern business practices. Genuinely independent contractors, like regional specialists, part-time contractors and micro business owners, are now treated as payroll tax liabilities, not partners in enterprise. New South Wales is taxing genuine business models as though they are loopholes, which is both unfair and economically unsound. Secondly, uncertainty and contradiction. The employment agent provisions are increasingly unclear due to shifting interpretations and contradictory guidance from Revenue New South Wales. What used to be a fact-sensitive analysis has now become, in the wake of recent legal decisions, like the integrated trolley management case, a mechanical contractual review, disregarding the practical realities of how services are delivered. Parliament did not agree to change the payroll tax, regulations, or their interpretation. Yet Revenue has changed its interpretation, contradicting years of legal precedent and leaving taxpayers like us in a sea of uncertainty. Picture this. You're running a business. Yesterday's audit gave you a clean bill of health, but today's audit, based on the same facts, flags a liability worth hundreds of thousands of dollars. This isn't a hypothetical. This happened to us and is happening to us. In 2017 and 2019, ARA Property Services were given a clean audit, yet in 2022 were audited again, and the State Revenue Office New South Wales changed their interpretation and decided to go back 4 years to 2018. We were forced to pay fines, interest and tax totalling $2.7 million. Third point, under retrospective liability. This is arguably the most dangerous issue. ARA, like many others, has experienced the fallout of retrospective audits, where past interpretations of the law are overturned and liabilities are imposed years later. One court decision, issued long after a tax year has passed, suddenly becomes the new lens through which historical arrangements are viewed. What does this mean for a business? It means reassessments, penalties, interest, all calculated on decisions that weren't even made at the time of doing business. It's akin to being issued a speeding fine today if the speed limits change tomorrow, only because the rules were changed overnight. Retrospective enforcement doesn't just create financial strain, it breeds fear, confusion and mistrust in the system. And fourthly, clear, consistent and practical guidance. Clarity and consistency are the cornerstone of a well-functioning tax system. We need consistent administrative guidance. Revenue New South Wales public rulings often conflict with their enforcement actions. While Revenue's rulings suggest payroll tax liabilities lie with the employment agent closest to the client, audits have then been conducted against parties further down the chain, a complete contradiction. When tax authorities shift interpretations without consultation or contradict their own published positions, it places businesses in an impossible bind. Compliance becomes a gamble rather than a guarantee. So in closing, I ask this inquiry to recommend the following changes. Modernise the payroll tax to recognise modern business practices and ensure only genuine examples of avoidance are targeted for compliance. Amend the Act to require the Commission to report to Parliament on their changes to interpretation. 3, prohibit retrospective application of interpretations. And lastly, ensure any future interpretation changes are clearly communicated so that businesses have time to plan and adapt. When taxpayers know the rules, compliance follows naturally. We need this inquiry to recommend changes to modernise payroll tax, restore clarity and consistency, and ensure fairness and economic resilience for New South Wales businesses. Thank you very much.
Thank you, Mr. McCann. Mr. Walker.
Thank you, Chair and honourable members. I would like to tell my story, and it's, I'm afraid it's going to be very similar to what I've already heard. I've been in business for 40 plus years, and during this time, after previous audits, I've never owed 1 additional cent in tax. Full stop. Indeed, the last audit for the period of 2017 to 2020 identified an overpayment by my companies of $6,000. Then at the last minute during this audit, and before it was finalised, Revenue New South Wales unexpectedly issued a demand for $1 million, plus penalties, plus interest, to be paid in 21 days, based upon its now interpretation of the employment agency legislation. And this is the nub of the problem. The legislation is totally unfit for purpose. From my colleagues on the right here, you've heard it. Government needs to rewrite the employment agency legislation to ensure it is relevant to 2025 business environment. The legislation was introduced in 1985, 40 years ago, and amended in 1998, 27 years ago. How different is the world today? Well before Google was even known. And I'm not alone in this belief. Justice White has similar views. Justice White observed in respect of the employment agency provisions that, and I quote, "It is not a case in which a literal construction of these provisions fails to address the mischief that Parliament was concerned to address, but rather a case in which the literal words used to address that mischief go far beyond the mischief intended to be addressed." Hear, hear, Justice White. Now, Silk has made a written comment here, and he is a little more succinct. He says, and I quote what he wrote, "A taxation law," and this is what we're all saying, "a taxation law is unjust if it is so uncertain that taxpayers are unable to confidently interpret and apply it. The volume of litigation over the employment agency rules in the last 10 to 15 years clearly demonstrate that not even judges and highly paid tax lawyers are able to consistently agree on how the legislation should be interpreted. These circumstances are crying out for legislative intervention," end of quote. And finally, and further in 1985, the concluding remarks of Mr Ernie Page, a Labor MP, at the time put government's position beyond any doubt when he said, and I quote, "The whole aim of tightening up on contractors and agents is to pick those who are avoiders. The Minister has made it quite clear that there is no suggestion that anyone who is a legitimate contract worker or a firm should face an undue imposition of payroll tax." Full stop, end of quote. It is therefore clear that the original intent of Parliament when this legislation was introduced is no longer being applied. And I have some other further comments to make. Retrospectivity. The retrospective period, I'm told, is about 5 years. In my case, Revenue New South Wales is seeking to go back 9 years. Obviously, what we're saying here is each business should be responsible for its own tax and no one else's. This is a very simple principle of fairness and common sense, and I would imagine desirable public policy. The current legislation does not provide this certainty. Communication. The Commissioner must communicate widely all practice notes. For example, email to industry associations, lawyers, accountants, et al., months before new rules are applied, so appropriate consideration can be given to them. Moratorium. The committee should recommend a moratorium of 6 to 12 months while all the above matters are being resolved, and all court cases should be halted during this period. And finally, we are, if requested, we will offer draft legislation, and the legislation that we will propose will not reduce the percentage rate of payroll tax, will not increase the threshold. Therefore, government will not lose 1 cent in tax revenue beyond the original intent of the employment agency provisions. Instead, it will simply result in each business being solely responsible for their tax and no one else's, and will not lose revenue. Thank you, Chair.
Thank you, Mr Walker. We'll now turn to some questions from committee members. Mr Tudor-Hope for the opposition.
Thank you. Thank you all for the submissions which you have made, which all outline the various issues which your corporations, or alternatively those for whom you act, have been facing. Mr Walker, in your concluding statement, you say you're happy to pay the tax that you're liable for, but not pay the tax for others.
Correct.
So just explain to me what you mean by that.
The legislation that I paid and the audits that I've had is that we meet what we thought then was the rules of taxation of employing people, and we paid payroll tax as required for the employees. The Revenue New South Wales has decided to interpret the current legislation differently. The fees that we pay subcontractors, bona fide incorporated contractors, they claim are basically deemed wages, and they apply the tax to that fee. Now, the department has, in my case, has not ordered any of these contractors, not one of them. They don't know if they are above the threshold or under the threshold. We know in one of our cases that they are under the threshold, but I'm supposed to pay tax on it. So suddenly I'm responsible for other people's tax.
So can you just give me a description of your business and what these subcontractors do for your business?
They provide services to what our clients want. So they might provide specialist services, special cleaning services. We outsource as clients outsource to engage us. With respect, we have a court case coming up, so I have to be a little circumspect.
Well, so just describe to me, what's your business?
Basically a cleaning company.
And you subcontract with?
With other providers who might provide equipment, labour, chemicals, whatever, specialist expertise.
Do those people only work for you?
No.
They work for other people as well?
Absolutely.
So the subcontractors that you engage to do work where you have the head contract,
yep.
They in fact may be also contracted to other organisations.
With the greatest respect, sir, they might even work for our client.
Yeah.
Exactly. It's not like the old story where if they work for more than 80% of you, they are a deemed employee. That's not the case. These are incorporated entities who have their own, most probably pay their own payroll tax, but certainly have their own workers' compensation and public liability. There's no association between me and the other parties. There's no cross-shareholding. They're independent contractors as viewed by the ATO. There's no relationship, none whatsoever.
So when you got your assessment for $1 million, did you challenge that assessment?
We are at the moment, currently, yes.
And that is in the Supreme Court?
Yes.
And when is that due to go to hearing?
Well, I can't answer that, and I'm not being evasive here, but later this year, I would imagine.
Do you know?
The date hasn't been set as yet.
When you got your, when you received an assessment in, I think you said 2017 and then 2019, is that correct?
The audited period was from 2017 to 2020, so it was 4 years.
Yep.
And I said that they went back 9 years retrospectively because the financial year ending in 2017, it started in July 2016.
And
so that's what they're starting to say you owe tax on.
And when was the first that you became aware that the subcontractors you've identified were deemed employees for the purposes of for the purposes of payroll tax?
Yeah. When my chief financial officer said, well, we've obviously because they alerted us we'd overpaid this $6,000, the person we were dealing with apparently said, I have to get approval to credit you the $6,000. And the answer came back, no, we're not going to pay the $6,000. We're going to view you under the employment agency conditions. So right at the end of the audit.
So before that...
we had no idea.
Had you ever been made aware of court cases which had been in the process of being decided or had been decided, which potentially may have exposed you to liability?
Not at all. Not at all. And my lawyers, accountants, other people we used had never come to me and said, look, you really should consider this. This is something which is potentially financially damaging to the company. We had no idea. It was first drawn to our attention formally in the written word, where they came back and said, we're now viewing your structure as under the employment agency provision, and I did not have a clue what that meant. I'd heard of employment agencies, but we're no more an employment agency than fly in the air. And so it then became a legal matter.
So, Mr. Diamond, you've said you don't want the legislation changed. Do you say this legislation is fit for purpose, do you?
Can I answer you in this way? We understand what a task it is to change legislation. We do understand that. What we're seeking here is practical outcomes. If it is possible to change the legislation, then absolutely we would support that. But we don't make that a main task here, if I can say that, honourable member.
Well, to give the clarity which you're seeking, isn't the best tool to change the legislation so that it does give you that clarity which you're seeking?
That is the best tool if it's achievable. If it can't be achieved, though, there is still open under the legislation as it's written for Revenue New South Wales to adopt an interpretation of it or to have a policy in place, which it says it does.
Well, currently the problem is, isn't it, that the courts interpret strictly the provisions of this legislation, and that's why companies like yours, on a strict interpretation of the current legislation, are being assessed as liable for payroll tax. So doesn't the legislation, if you're going to convince a court that you are not liable for payroll tax, this legislation needs changing, doesn't it?
You will get no opposition from my client or myself to that, sir. Absolutely. But as I said, we do appreciate how difficult it is to change legislation.
Isn't it the case, and others may have a view on this, isn't it the case that Revenue say, we are just applying the law? And if this is the law, doesn't the legislation need to be changed?
Yes. Yes, it does. When you in that context.
And in each of the decided cases, and in fact, if you go to the loan mark decision, it says this: the potential difficulty for a taxpayer is that the exclusions are very specific and may leave a subset of relationships, such as those in the present case, where the contractor is a genuine independent contractor, but they may not come within the exclusions. Yep. Isn't that exactly the problem?
Indeed, and there have been a number of Supreme Court decisions, and it would appear that the judges don't agree amongst themselves, so it's doubly problematic for a business. Well, if the legislation can be changed to bring absolute clarity so that this problem goes away, then hell yes.
What I'm putting to you is it must be changed. I'm putting to you, it must be changed if in fact you're going to get rid of the ambiguity which currently exists in relation to the interpretation of this Act.
I'm not pushing back against that one iota, sir. Not at all.
Just let me understand this. What's the model of the employment contracts which you enter? Are they the same as Mr. Walker's?
Yes.
Where you have subcontractors, there's a head contractor and you have subcontractors potentially who carry out that work on behalf of the subcontractor.
That's quite right, and that's what happens through the industry, and Quad has that model the same as Mastercare.
And have you received retrospective tax assessments?
Yes, yes.
And what's the quantum of those retrospective tax assessments?
It's in the millions of dollars.
Have they been challenged?
Very much so.
By way of proceedings against the Commissioner?
We are not at the litigation point yet. We have filed a formal objection. We've had one brief meeting with Revenue New South Wales about that, and we are awaiting the results of the objection.
And can I ask this, the assessments that which your client received, was in respect of a period of tax, then a retrospective period of tax and penalties in addition?
That is correct, yes.
What was the quantum of the penalties? Do you recall?
It effectively doubled.
The penalties doubled the amount of tax.
Yes.
Tax which was claimed.
Penalties and interest effectively doubled what was owed.
If in fact the law wasn't to be changed, what's the impact in terms of the cost of the provision of services provided by your company to the various under the contracts which you've entered into? If you were going to pass those costs on to
I see.
the consumer, so to speak.
I would prefer to be able to give the honourable member a completely accurate answer.
You can take it on notice.
I'll take it under advisement. And can we correspond with the committee on that?
Correspond with the committee and write to the committee and respond.
But it'll be significant, that I can tell you.
May I offer?
Sure, Mr. Wood.
Yeah, thank you. Is a broad brushstroke. You're talking about at least the quantum of the tax, which in New South Wales I think is about 5.5 or 5.45. And then you've got other administrative things. So you're talking about possibly a quantum of up to 10%, if not more. And that's just a broad idea of what the administrative
the payroll tax plus the administration which you would pass on.
Exactly. Which would cost industry and the clients, which would put up their prices, and very tough. And and that's one of the reasons you have to have a moratorium, because as I've said, we are prepared to give draft legislation, so it's totally changed the law, so everybody has clarity and confidence the way they're running the business. Everybody sitting here, including the association, is telling basically to me the same story. We're all honest taxpayers. I've been around for 40 years plus in business paying my tax, and suddenly you feel like you're a bloody enemy of the state because they come along with this interpretation which is unfit for purpose and say, thanks very much, you've paid all your tax, you've overpaid by $6,000, but you now owe $1 million plus because of the way we interpret the legislation, which is 40 years old, totally unfit for purpose.
Can I jump in and ask a few questions? Thanks, Mr. Vigor. I'm interested in exploring a bit more about the employment, the contracting down your subcontractors chain. Mr. Tudor asked you about that. I wondered particularly, Mr. Diamond, could you explain, you said that the arrangements were similar to those explained by Mr. Walker. Mr. Walker, I think you said that the businesses that you engage with are incorporated.
Correct.
So, and Mr. Diamond, does that mean you note in your submission that you have 2,000, I think, 3,000, 2,000 cleaners in New South Wales that you engage with? Are they incorporated businesses or are they people with ABNs? I'd like to know a bit more about the people doing the work.
The individuals who clean don't hold ABNs. They're employed. Mm-hmm. They're either direct employees of Quad or they're employees of a subcontractor. Mm-hmm. The reason subcontractors get used by principal cleaning contractors is that they have expertise that the cleaning contractor broadly doesn't have. They're able to source labour in areas that are difficult, where the principal cleaning contractor doesn't have a good reach, and similar other differences that arise when you compare with the direct workforce.
So you say, so Quad employs some cleaners directly, is that what you said? Okay.
Yeah.
So
and you'd pay payroll tax in relation to...
Yeah.
Absolutely.
Sure.
What
sorry,
happens
if I
is
could
you...
just... Sorry, just because I'm on a bit of a roll in my own head. So you employ some cleaners directly. You've got some that are outsourced further down a subcontracting chain. How many have you got directly employed? And then we ask the same of the dentists. How many, I guess, or what is the nature of the companies that you engage with, the subcontractors? How big are they? How many cleaners do they engage? Could we get even on notice, a list of those so we understand the nature of that subcontracting chain?
I don't think there's any problem with providing you with a relative breakup, so because that's what you want to know, isn't it?
Yes.
How much is direct employment? How much is subcontracting engagement? That's what you're
Yes,
seeking to
and then
get
the
to.
next thing is not only is how much is subcontract engagement, how much of that subcontract engagement is done by bigger organisations, by smaller organisations, or indeed by individuals?
Speaking for Quad, most of the subcontractors are of substance and size.
So you could provide information, more detail of that on notice?
Yes.
Okay, all right.
And happy to correspond at the same time that I do the other. Can I say this to all of you, please? In 2016, that was the first time as an advisor to Quad that I was aware that Revenue New South Wales was looking at the employment agency provisions. Following correspondence, senior management from Quad and me, we went to meet with Revenue New South Wales, senior officials out at Parramatta. We discussed it with them. There was quite a debate about what employment agency meant. And then subsequently they wrote to us and said that it was that they were not going to determine the issue, but regarded it as essentially a matter of self-assessment. Quad went away, took advice. The audits were then completed and, based on the correspondence, no problem. Then another audit's conducted in 2022, and it took quite a while. There were significant gaps. Months went by when we didn't hear from Revenue New South Wales. But almost as soon as the integrated trolley management decision was handed down, suddenly Revenue New South Wales was issuing assessments, not just to Quad, but to plenty of other companies, on the basis of employment agency. Retrospective 5 years, even though the decision was only made in December 2023.
Thank you, Mr. Diamond. I appreciate that, and I appreciate the context that you're given, and I might ask you a bit more about that in a second. I'm still interested also in the relationships down that subcontract chain, so I understand. So please bear with me for a little while longer. So you've said that Quad employs some cleaners directly, and then it further outsources others because there's specialty kind of areas. So of the 2,000 cleaners or so in New South Wales engaged, and you said you can find proportion, can you give me a ballpark of how many are engaged directly by Quad and how many specialist services you have to go, specialist services in cleaning you then have to go out and...
As I said, I can provide that level
Okay,
of
any
detail
ballpark?
in
Or you don't? You don't have a ballpark figure on that for us now?
I only want to tell you something that's completely accurate because we are on record here and I am under oath.
Sure. Appreciate that very much.
I think just having a broad swing at it, honourable member, would not be right.
No, I appreciate your diligence in that respect. I'm interested in your submission. You talk about control and the types of control that is cited as being necessary to prove different types of relationships. So could you sort of maybe give an example of the differences between, a cleaner who you send out as a direct employee to a client and someone who is under some other contracting arrangement? What would be the differences in the instruction given to them or the levels of control that you refer to in your submission?
In broad scope, if a cleaner is employed to do a task at a client's site, there'll be a set of specifications, there'll be some directions given to the cleaner by the management as to what to do, and that will be checked for satisfaction, quality and performance standard.
So that's regardless of whether they're employed by you or whether they're...
No, I'm talking about an employment relationship. If a subcontractor is engaged, generally that model changes somewhat the subcontractor is told what the client wants, but the subcontractor then makes a determination about what labour it will engage, and it takes up the task of managing that labour. That's what happens.
Could I ask a question? And this one will be, I expect will be on notice. Have you got any sense of the demographics of the cleaning workforce, both within your own with Quad's directly employed workers, but within the subcontracting workforce?
In terms of country of origin, gender?
Age, demographics, generally.
We can certainly provide the information to the extent that it's collected. That can be done.
That would be very helpful. Thank you. And I wondered if I could go, and this is to everyone as well. And Mr. Walker, I might probably on notice ask you similar questions that I've asked Mr. Diamond, given the similarities in your stories and your businesses. But I want to go back to what you were talking about, Mr. Diamond, in terms of the cases that seem to have changed in interpretation. That's what I'm hearing from you, might have changed in interpretation. So I think there were some key dates. I think 2017, 20...
No, that was my submission, I think.
Okay.
It was 2017 and
okay,
2019.
so if I could just maybe take that as a point in time for us.
Yep.
If I could get from each of you maybe from about... let's take 2017 as a point. I guess your interactions with not state revenue, we've heard about the differences there, but with the government and ministers around the situation. So between about 2017, at the time when key cases were heard, or you saw you had activity, did you engage with government rather than revenue, or as well as revenue?
Well, I don't understand that. Sorry.
If I could start with our example.
Yep.
Obviously, we didn't have any engagement with any government officials, but in 2017 and 2019, we had separate entities, but cleaning. Both passed an audit around exemptions under being a contractor. Fast forward to 2022, we had a similar audit, and currently 2024, we've had an audit, and we've issued, in one example, the same contract. They often ask for a sample of a contract, and it's the same contract that we had in 2017.
Mm-hmm.
And currently, it's been deemed, no, it's all employment agency. And we went back and said, well, what's changed since 2017? Here's the same contract. And it was very much, no, we don't really want to talk about it. All your contractors are deemed to be employment agents.
Okay, thank you. That's very helpful.
And to the point of, in a current audit letter, there was a commentary saying, oh, look, it was probably an oversight in 2017.
Right, okay.
So that means there's been 2 oversights.
Mm-hmm.
Yeah.
And we're currently in the process of having to pay $750,000 in the next week because we obviously are going to fight it, but we're a business that has, whether it's banking covenants or whatever, we have to pay it. In dispute.
Did you provide that audit letter in your submission?
No, but we can certainly, we've got all the documentation around the audit, so yep, if we need to submit that, absolutely we could do that.
Welcome.
Yeah.
Sorry, could I perhaps maybe I could go to Ms. Puxty then as the peak body. That might be, I might restate the question, which is between, and we're taking 2017 as and now, did your organisation as a peak body have correspondence or have meetings with any government ministers during that time around this issue?
We were unaware of the issue.
I think that's the point.
It was.
Sorry, I would just like to give Ms. Puxty a chance.
We were unaware of the issue. The issue was not brought to our attention until close to the end of 2023 by several members who had gone through an audit, received their notice. I then, on the 18th of October 2023, reached out to Revenue New South Wales, introducing myself, the association, and seeking assistance in any education that they could provide around employment agency. Unfortunately, after many other emails that were sent to Revenue New South Wales, I received no response for over 5 months. I did make contact with Revenue New South Wales and spoke to their representative answering the phone. Their direction was, we don't know how to assist you with this. We generally tell people to go to the website. It turned out to be quite fortunate that I had a meeting with the Service New South Wales Business Bureau on the 21st of February. We discussed other topics. I brought this issue to their attention. They advised me that they would speak to Revenue New South Wales. That afternoon, I received an email from Revenue New South Wales reaching out to address the concerns that I had. From that time in February, I was not able to coordinate a meeting with them until May. And then from that meeting in May, we were able to coordinate a presentation to members in New South Wales in June, the 19th of June, approximately.
Thank you very much for that. Thanks. Thank you, Chair.
Thank you, Dr. Kane.
So,
Mr. Tudor.
Mrs. Bhakti, in terms of the members of your organisation which may have been subject to these orders, how many would you anticipate have been the subject of an audit?
I could give an approximate if that would help. I would say 6 that I would feel confident in saying, but I would be happy to provide actual information on notice if you would like.
And you say you have now had a seminar with Revenue New South Wales who have explained potentially how the law is currently being administered?
We did. The invitation went out to all our members. At that time, it was in June 2024, and I believe the response to attend was quite limited. I think that was around the hesitation, and a lot of companies were actually going through audits at the time.
When you say a lot of companies?
Sorry, there were companies going through audits at the time.
And this is potentially across the board. Have any of you changed your work arrangements or contracting arrangements since 2017?
No.
No.
And this is the problem.
No.
We're doing business how we're doing business, ARA Property is doing business, and we get a tick, and we haven't changed it. As I said, we put a contract in that's still, 9 years old. So it's like doing business with your hands tied behind your back. We haven't changed our practices. If we were told to, or we had some guidance, then that's what we do. We would change our practices.
Well, let me ask you that. How would you change it, given that you probably now are made aware of the provisions of recent decisions? How would you change it?
Well, we would have to look at our business model. So whether we engaged more direct cleaners, or whether or not we, in essence, paid tax on our contractors. Like that's the balance. And Mr. Walker said it. There's a potential cost to that, to whatever our clients are. But I mean, it's a modelling thing. Yeah.
Why can't you employ more? Why can't you now? What stops you now employing? Apart from this specialist idea.
Yeah, the example that you were there was a few examples. I was thinking in my head, a perfect example is, if we win a small little contract in Dubbo, and it might only be an hour a night. So you've got award conditions with minimum engagement. So we would generally reach out to a large contractor in Dubbo. So, and we would engage them, and sometimes we might even put a small tender out and say, look guys, who wants to do this work? Like, it's an independent, they've got their own business, they've got their own website, they're probably working for Quad and Mastercare for all we know.
Nearby.
But we can't employ someone in Dubbo for an hour. We'd have to charge potentially 2 hour minimum. And then the client won't want to pay that. So that's a bit of the modelling, or it could be specialty services. So steam cleaning, or high-level glass cleaning or strip and sealing. So there's a mix there of regional and specialty. Yeah.
And
If I may say, and if I can quote again what the Silk said, and why I believe the law has to be changed, and we're prepared to offer a draft. And I think he sums it up in this one paragraph. He says, a taxation law is unjust if it is so uncertain that taxpayers are unable to confidently interpret and apply it. Full stop. That's it. And then he goes on to say, not even judges and highly paid tax lawyers are able to consistently agree on how the legislation should be interpreted. It just shouldn't be like that. It should be clear-cut so we know that we're observing the law. No one sitting at this table is an avoider, as Ernie Page would say. We all pay our tax. We mightn't like it, but that's got nothing to do with it. We pay our tax to the guidelines. Revenue New South Wales has come along and is interpreting differently a tax which is 40 years old. If you had a house, you'd give it a lick of paint in 40 years. You'd most probably renovate the bathroom. For modern day business to try and comply with this tax is impossible.
Mr. Tudor, anything further?
Have you read the submission, or your legal advisors read the submission of the Commissioner?
Yes.
State Revenue?
I have not. I've heard it's a little bland.
Have you read the...
I have read it.
And do you have any observations to make in relation to that submission?
Nothing.
I'm always mindful of ongoing relationships. Can I seek an indulgence and respond to that in writing, please?
Yep, that's fine.
Thank you.
I think nothing overly productive what the Commissioner has said. I think it's an attitude, it could be, and I obviously don't know, it may be an attitudinal thing. I mean, I'd be interested to know why the Commissioner has suddenly become very active in issuing demands on this interpretation. What is the motive of doing it? I mean, if the majority of people are honest taxpayers, we're talking about the 98% of us who pay the tax according to the law as we understand it, and we don't want to go to lawyers and tax barristers to make sure that we're observing the law. Surely, as you've suggested, sir, that the legislation just has to be changed so it's clear cut, and then we all get on with our business. I disagree slightly with Paul here, Mr. McCann here. I don't want to modify anything. I just want to know what the law is, and then I'll go about my business. I don't want to have this law remain as it is because it's an incredible impediment of doing business. And it's an incredible impediment on the economic structure of New South Wales. They're putting people out of companies, out of business. They're creating unemployment. The biggest tax revenue in this state is now payroll tax. It makes no sense. And to me, and I'm obviously not a politician, it's a relatively easy fix that if government says this is the new legislation and we have this moratorium for 6 or 12 months while we got all this sorted, we put a halt on the current court cases, and we've got resolution. And because it is unfit for purpose, it does not work. Full stop.
I just have one more.
Dr. Kane.
So, and forgive me, I am just trying to, make sure that I've got it clear in my head how it all works between, the different tiers of the chain. So, in terms of the requirement to declare subcontractors and for the subcontractors statement, your organisations would be collecting those from subcontractors statement that's required.
Yes,
so
correct.
So your organisation every
Correct.
month you get that
Yes.
from all of your. So that's what you do. That's not others doing that down the chain. You're the ultimate, I guess, holders of those subcontractor statements.
Well, that's not relevant to this problem, because the problem is to answer your question, yes, we always get subcontractor statements and they don't get paid. We're dealing with incorporated entities and we will pay some of these millions of dollars in fees to do work. And as Mr. Diamond said, one of the reasons you do it is because that Australians aren't all that willing to work, and these subcontractors of different nationalities, and they've got a deep reach into their communities, and these people work.
Sorry, I'm just not clear what you mean by Australians. So you're saying that these are people
Australians in general don't wish to do menial jobs, in my experience.
Right, okay. So you've got a lot of visa holders or students?
I don't know what it is, but they're Australian. They're either Australian citizens, but they're legitimate citizens in Australia. They're quite legal.
Yeah.
Because we check that. Because the taxation department makes sure that that's the case.
Right, okay. All right, thank you for that.
Thank you, Dr. Kane. Anything else, Mr. Tudor-Hope?
No, I'm good, thanks.
All right, well, thank you very much. In the absence of any questions, that concludes this section. We very much appreciate your submissions and your testimony here today, your answers to the questions. We very much appreciate it. The committee is hearing loud and clear your concerns. We will be in contact through the Secretariat in due course with any matters that were taken on notice. But again, thank you very much for your submissions, your evidence today. You're free to go. Thank you.
Thank you to all the members. Thank you for listening to us.
Thank you very much.
We appreciate it.
Afternoon to our witnesses. Thank you very much for your attendance to today's hearing. Before we begin, could I ask all of you to please state your name, position, title, and swear either the oath or affirmation. And we'll start on my left with Mr. White.
Good afternoon, and thanks for the opportunity to appear before you. My name is Sam White. I'm the Executive Chairman of Loan Market Group. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Ms. Panek.
My name is Anya Panek. I'm the CEO of the Mortgage and Finance Association of Australia. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you very much. Mr. Bushby.
Thank you. David Bushby, I'm the CEO of the Commercial and Asset Finance Brokers Association of Australia. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. Do you have some introductory remarks to make, Mr. White?
I do, if I may. So thank you for the opportunity to appear before this committee. The recent decision in our case against Revenue New South Wales has left the mortgage broking industry grappling with some serious consequences. Whilst we lost our case, the judge called the outcome harsh and highlighted the law's complexity that makes it difficult to apply fairly. His honour illustrates that the exemptions, while available, are hard to evidence, particularly for aggregators like us who are required to source detailed evidence from hundreds of independent brokers operating as small businesses. This complexity has been our experience through nearly a decade-long process, compounded by limited guidance from the regulator and burdensome inconsistent approach to audits. Though the court ultimately reduced our payroll tax liability by 65% of the original assessment, or 65% of the original assessment, to 65% of the by 65% of the original assessment, the broader uncertainty remains unresolved and is now landing squarely on small business owners and brokers across Australia. There are approximately 22,000 mortgage brokers in Australia, a quarter of whom choose Loan Market Group to be their aggregator. Most are sole traders or family-run businesses. They're now facing a new tax on their revenue, not their profit, which for many is unsustainable. If I can just explain how the numbers work. If a broker, say, earns $300,000, they might pay Loan Market Group, say, $15,000 in aggregation fees. The outcome of this case means that we would now be required to pay $16,800 in tax based on the broker's earnings. So we make $15,000, but we have to pay $16,800 to the payroll tax office. Across the board, if we did not have exemptions, which were granted by His Honour, but if we didn't have exemptions, the payroll tax would be more than 60% of our total revenue every year as an aggregator. So we can't sustain that. Obviously, no business can sustain that type of cost. So we have to pass it on. We've been having discussions with brokers about this, and we will absorb the previous amounts that have been for the back tax. But we've been saying we can't absorb this moving forward, that we will need to pass on that 5.6% to them and to the smallest of small businesses who cannot establish an exemption. It's these brokers that will feel the impact. And today, 76% of Australians rely on mortgage brokers to secure a home loan. These small businesses play a crucial role in helping everyday Australians get a fair go at with their finances. And I urge this committee to ensure that this law is clarified and changed if possible, the drafting made clearer, and its administration applied fairly to protect small businesses and the Australians they serve.
Thank you, Mr. White. Ms. Panic.
Yes, Chair, committee members. Thank you for the opportunity to speak today and to represent the approximately 6,000 MFAA members in New South Wales, mortgage and finance brokers, aggregators and lenders. Mortgage brokers, as mentioned by Mr. White, play a critical role in Australia's lending market, providing choice and competition and helping more than 75% of Australians secure a home loan. Brokers are overwhelmingly independent micro and small businesses. Now, the broking industry has actually been in existence since the early 1990s, with brokers running their own businesses, sourcing their own clients, and working on behalf of these clients, sourcing loan options. Aggregators emerged in the mid to late 1990s, offering services to brokers so they could operate their businesses and secure and support their clients more efficiently. Now, despite all these facts, drafting of the relevant contractor provisions and the recent loan market court ruling now treat these broking businesses as employees of aggregators. They are not. Aggregators provide services to brokers. Brokers are independent small businesses. When first introduced into the Payroll Tax Act in the mid-1980s, the relevant contractor provisions were intended to address anti-avoidance. They are now capturing businesses, such as broking businesses, in a way never intended. This threatens not only the viability of small broking businesses, but also the ability of New South Wales borrowers to access a competitive home loan, as less brokers means more expensive mortgages. Our submission highlights the opportunity for this inquiry to recommend changes to the law so that it reflects its original intent, and in doing so, provides clarity not only to the broking industry, but to the many other small business industries who have provided submissions to this inquiry. Thank you, and I welcome questions from the committee.
Thank you. Mr. Bushby.
Thank you, and thank you also to the committee for giving us the opportunity to present today. CAFBA is a not-for-profit association representing finance brokers whose primary focus is assisting business clients source the finances that they need to grow their businesses, create wealth for communities and employ Australians. Small businesses tend to be experts in the field in which they operate, but not in how to get the finance they need, in the structure and timelines that best suits their particular business's needs. The finance needs of small and medium business varies widely, from new office equipment through to heavy factory machinery, commercial property finance, yellow goods, working capital, the list goes on. Assisting businesses with these needs requires a high degree of knowledge and expertise. We have around 1,000 individual members associated with around 500 broking business members across Australia. CAFPA welcomes and endorses the opening comments made by the CEO of the MFAA and also of Loan Market Group. The aggregation model in finance broking developed in response to a market opportunity and need to provide services to finance brokers that better enabled them to service their clients efficiently. Commercial and asset finance brokers are generally paid by lenders and pay a fee to aggregators for the services that they supply, such as customer record management systems and other IT systems. The legislation being considered by this inquiry contains provisions intended to address arrangements put in place to avoid and evade tax properly paid by an employer in relation to their employees. The relationship between aggregators and brokers is not such an arrangement and should not be caught under such provisions.
Thank you very much. Questions now from the opposition? Mr. Tudor.
Thank you for being in. Thank you for your submissions. You've sat through and heard the evidence previously given by various contractors, and I take it is a similar sort of story which you're telling. Can I ask you about your relationship with Revenue New South Wales? You've obviously now been through the whole hoop, got the assessment, challenged the assessment, I assume by way of objection in the first instance to the assessment, and then lodged an application with the Supreme Court challenging the assessment, which ultimately was varied, but you still were subject to payroll tax. In summary, I think that's where...
Yes.
So on the very first... When was the very first time that you were the subject of an audit?
I believe it's 2015.
And when you were the subject of that audit, had you ever been audited previously?
No. Well, for payroll tax we would have been previously, but not for payroll tax for brokers, no.
So you had been audited for payroll tax in your own right, for your own employees,
yes.
But for the purposes of that audit, brokers were not included as part of the audit. Is that the case?
That's my understanding. Although I don't have direct knowledge of we would have been audited, but we've been in business for 30 years, so we would have had some sort of payroll tax audit in the past.
So in 2015, you were asked to provide the records. Is that the case of all the brokers for whom you provided services?
That's right.
And did you query that at the time?
Yes, we did. And we worked through a process with Revenue New South Wales. We thought it may be a misunderstanding that we could explain how things worked, and we did that for. I believe we got the final the actual assessment in 2018. So I believe it was 3 years, and during that time we thought that we had a short number of meetings with Revenue New South Wales. We obviously gave them a lot of information. And obviously their decision was that it was a different position to what we thought it was going to be. So in 2015, when they come to see you, they ask you for the brokers' records. Yes.
And you queried that. What explanation did they give as to why they had formed the view that they wanted to see the brokers' records?
I can't recall. I can find out and come back to you.
Was there correspondence relating to that?
There was correspondence, yes, between us and Revenue New South Wales.
So had there been a decision that you were aware of which may have given rise to a circumstance?
My recollection, and through the discussions we had with Revenue New South Wales, was that they referenced Bridges' case, which I think was a 2002 case.
Which case?
Bridges, yep. Bridges.
Yep.
And that in their correspondence with Bridges was a significant part of their, and there wasn't a lot of detail in the letters that we received, but we were required to give them all the information. We had all our records on our brokers, on brokers that were choosing to use us through for 5 years prior to 2015.
Now, was that material which you had readily at hand, or did you have to engage in a process where you had to collect that information from...
A lot of this was new. We didn't know... So a lot of the information we had at hand, we had all the information at hand that we had. What we didn't have was some of the requests that they asked us for subsequently. For example, how many people did that particular business employ or engage? We didn't have that information readily to hand, and we had to end up surveying and talking to all of our the brokers who were both prior, who had left our group, and brokers who also were with our group. We had to go and find out from them and survey them and say, how many staff do you have? So there was information we needed to collect, and some of the information we had.
So in 2018, you actually got the assessment
yes.
from Revenue.
Yes.
And then lodged an objection.
Yes.
What process did that objection follow?
I believe we followed the internal process, which was to appeal to the manager of the person who was conducting our audit. That process, my recollection is that came back with a slight variation in the amount, but reaffirming the liability, and that was then required to be paid within a certain period of time, and that we then needed to, if we wanted to go further, we needed to challenge that illegally, which we did.
Do you recall the amount of that assessment?
Not precisely, no.
Did it include retrospective tax?
Yes, it went back to, for a period of 2012 to 2018 was the period.
And did it include penalties?
Yes, it did.
When you went to court, were those penalties removed?
The penalties were, some of the penalties were removed, some were not, as I understand. But I'd need to get our lawyers just to clarify exactly which parts were there and which parts weren't. But I remember the judge, the conclusion that was that just because the law was confusing doesn't mean there's any reason why the penalty shouldn't be applying. So there was some relief given, but obviously there were still some penalties that were involved.
So even after the court decision,
yeah.
You were faced with an assessment for payroll tax on the amounts which you paid to brokers.
Amounts which were distributed through lenders to brokers through us.
Sorry, let me just clarify that. So the position was that the actual fee payable to the broker was not paid by you, it was paid by the actual
bank
lender to the broker.
Yes, we have 130 lenders on our panel, and broker is licensed, or they need to be accredited with each lender to be able to operate. The broker sees a customer, they submit a loan to a lender through our technology platform.
Yep.
The lender then remits payment for that if the deal settles through our system, and we remit that through to the broker. So the flow of funds goes through Loan Market Group to the broker.
But if there is a fee payable to the broker, it's not payable by you.
No.
It is a fee payable by the lender.
Yes.
And does that include tailing fees?
Yes.
So they're all payable. Say, for example, a loan was organised with the Commonwealth Bank.
Mm-hmm.
Any fee payable by the broker is not payable by you.
No.
It is only payable by the bank. So the arrangement between you and the broker and the amount which they pay you in relation to the service you provide, is that based on the opportunity and technology which you make available?
Yeah, so there are about 15 or 20 other aggregation groups, I believe, in Australia. We compete for brokers to say, please you choose us as your aggregator.
Yep.
The broker then pays a fee to the aggregator, and that fee varies depending upon what they would like, services they would like, but they always include things like access to lenders, for which you can't actually, if you're a broker, you need to be a broker, you need to be licensed, and you need to have an access to lenders. The only way to do that is through aggregation panels, because lenders don't deal directly with brokers.
Yep.
They need to deal through these intermediaries, which is what we've become.
So the assessment for payroll tax, though, was based on the fee which the broker paid to you.
Yes. No, it was the assessment of payroll tax was based on the fact that the bank paid the broker through us, and the amount of money that went from our account into the
Broker's
account, that was the amount accessible for payroll tax. So in some cases, we actually pay 100% of that fee that the lender pays to the broker. When we have a number of different models that brokers can choose from, 100% of that fee will go to the broker. The state revenue will say we need 5.6% of that fee because that's payroll tax, even though there is
no benefit to you.
No benefit. The broker pays us a fixed monthly fee.
Yep.
In those circumstances.
That fee isn't revenue for you.
The fee that the broker pays is revenue to us. The fee that the bank pays to the broker.
The fee that the bank is paying to the broker is not revenue to you.
No,
it just passes.
It is.
It just passes.
In
some cases.
Yeah, it always passes through. Now, the accounting standards require us to put our revenue as that fee in our accounting standards, and that was part of our case, but part of the complexity of that. But the entitlement to that revenue is the brokers. If a broker leaves us, we continue to pay that money to them. We're contractually obliged to make that payment. So it is not our money. I've never looked at it as our money. We don't take that money. Our revenue is the money that the broker pays us.
Can I ask, what's the sort of turnaround time? So you get you're holding that money to give to the broker from the bank. So how long do you keep that money?
We pay 3 times a month. So banks will pay intermittently. So some banks will pay on the first, some on the second. Some will do 2 payment runs. Some will do upfronts in some months. In the first week of the month, and then they'll do another payment on the 3rd week. We pay 3 times. Some brokers ask us to pay them monthly, but we pay 3 times, and we're actually trying to increase that number. But 3 times a month is our payment cycle.
Okay, so 3 times a month. So it's not a case that some banks you'll have particular amounts of money sitting in your bank account for a month. You'll be acquitting that, whatever it is. So it'll be a week and a bit sitting in your bank account.
Yeah, there is a particular case that some loans are unmatched, where, for example, we might need to work out who actually has done this loan if there's some complexity. So that's a very minor part, maybe 1% of our total volume that goes through might be in that. And that might be the case until we actually clarify which broker has written that loan, if there's some ambiguity about it. But the vast majority passes through very, very quickly. So 3 times a month is our payment cycle.
Okay, and sorry, you did say, my apologies, you did say the amount of brokers that you have.
It's about a quarter of brokers in Australia. So we have about just nearly 6,000 brokers throughout Australia.
Okay, 6,000. And
they all have separate ABNs?
As a rule? The vast majority would, not all of them, but I would, in the spirit of trying to give an estimate, I would say 95% would have their own. They all need to have their own accreditations. They need their own insurance, professional indemnity insurance policies, and they all have their own client base.
Can I ask a bit more about the relationship? So if I asked you about the relationship, you might call yourself an aggregator, but can you explain a bit more the relationship between
it's confusing.
The brokers? Well, I don't think the technical parts of it are confusing, but I think how it appears is because of different branding, different... So if you
it's evolved, the industry's evolved. I was a broker 30 years ago, and we, over time, when we first started, we used to have go and get our own accreditations with lenders. We had to get our own agreements. So I'd have to go and get 5 agreements, but I was only seeing 20 clients, and so I really could only help, support 20 lenders because I support 5 lenders because lenders only accredit you if you could give them volume. So over time, we started to share accreditations between brokers and said, look, can I use your your relationship with CBA, and I'll give you mine with Bank of Melbourne, and I'll pay you 5% or 10% of the commission. That's how our industry started in aggregation. And over time, it became that's how our industry evolved. So now we have 130 lenders, and we don't have now accreditations to write loans. We're now an aggregator. We have a number of different models that we offer our customers to choose from. Some are branded, where we say we can give you the Loan Market brand, and we'll give you a marketing system, we'll help you generate leads and clients. And others say, I don't really want that. I'd like to have my own brand, and I want to have my own ability to. I don't need to pay for that for your brand, Sam. I'll use my own, and so they have a different model. And His Honour.
Just on that one. I'm sorry, didn't mean to interrupt. What's the breakdown in terms of your 6,000 between those who do the branded thing and those who?
It would be about 600 individuals would trade under the brand, and about 5,000 would have their own.
Okay, so that if you wouldn't Google loan market, for example, and get those people on your website or your external facing things?
The ones who don't share the brand?
Yeah.
No, they have their own lead acquisition models, and for them, they pay us for technology, access to panel of commission payment systems, a lot of our reporting, and some of the things to help them run their business.
Yeah.
But the people who trade under the brand would pay slightly different fee structure to us.
So do you think that they're the same relationship? Sorry.
So His Honour considered this in the case. So our case went over two periods. One before we were a franchisor, and part of our case was after we became a franchisor, which was 2016. And in that case, His Honour considered we had people who were trading under their own brand prior to 2016, and people who were trading under their brand after 2016. And in that case, he said there's no difference between those two periods. So the brand did not make a difference to His Honour in his judgment, because he had the opportunity to distinguish the facts, because we do have people as part of that payroll tax case that weren't being paid, weren't part of the loan market brand.
No, I'm just intrigued, because when you Google and have a look, there's a lot of talk, which I presume are those 600, about our team. We do this, we provide this, we'll direct you to our team. So it very much seems a much closer relationship.
We're a franchise group. So we share the brand, we have culture that we're proud of, and we have we are a team.
No, it's an interesting differentiation, that's all. Thank you.
We're not trying to relitigate your case.
No, I'm not. No, I'm genuinely sorry. I'm not.
I think the thing about I am proud of what we've built, and I do look at our people as family, and I don't think that makes us bad or wrong. I don't see how that makes us in some way exerting more control over our people than anything else. But we do care for our people, and they're our customers. They can leave us any time. If they can give us 14 days notice and walk out the door, and when that happens, it's a kick in the guts. But they are our customers, and we've got to do everything we can to earn the right to keep them our customers. And part of that is providing an environment that they want to choose to be part of.
No, I mean, to Mr. Tudor's point, certainly I would never try to relitigate that case here. However, in saying that, a lot of what we're presented with is differences in decisions. In circumstances. So I am trying to understand what it is about different cases and different industries, because that's the other aspect of this. So I just wanted to give you that context.
One thing is His Honour did distinguish and said there were bona fide independent contractors, that they're people, that's what the brokers were, that they weren't an extension of an aggregator, that an aggregator and a broker were very different, and even in the Royal Commission, the Banking Royal Commission, when Commissioner Hayne was talking about the structure of our industry, Commissioner Hayne spoke a lot about the services that an aggregator provides brokers, but His Honour sort of looked at it and said, well, because the broadening is so broad, money does flow from a bank account into ours to the broker. The broker therefore provides services to us because effectively that's our business, is to generate revenue. And so his comment was how broad that definition was, even though it was very clear that we were providing services to the broker and that they were our customers. His conclusion was that it was so broad, and I think he used the language about that it didn't catch the bona fide contractors. So it didn't exclude that. We were caught up in that mix. And I understand you need to have legislation that protects the payroll, that protects the tax base, but I think this was a case where he acknowledged that he wasn't open to make that finding given the breadth of the language in the statute.
Are you appealing this to the Court of Appeal?
No, sir, we're not. We made a decision that our people need some clarity, so we've gone out and we've said, unless you can fit into an exemption, our brokers, then we are going to need to pass this on from you from FY25. We'll absorb everything.
And what's the impact of doing that?
So if you can establish an exemption, it generally means there's a number of ways you can do that. The main one of which is to engage someone in your business. There is some confusion as to what that actually means as to engaging someone in your business. If you can't establish that, we will need to reduce the commissions by 5.6%, which is the amount of the payroll tax for those people that can't establish they've engaged someone. The problem we run is that we're not sure exactly if our definition of what engaging someone is and Revenue Department in all the states. So we now need to, we're engaging with Victoria, we're engaging with Queensland, we're engaging with South Australia, and their evidentiary burdens are different, even though the legislation's the same.
So your model, in fact, exists right across Australia, does
Yes.
it not? And
yes.
Whatever happens in New South Wales, you would like to see a harmonised outcome.
Harmonisation's been great, except when it is so, and it's been interpreted very differently in New South Wales, well, first, and then other states now following New South Wales. So we would like it to be consistent, if possible. But it's not just the statute; it's the interpretation of the facts and how evidence is collected and managed. So we need to go to individual brokers and determine, have you engaged someone in your business for more than 90 days in the last 12 months? And if you can't establish that, if we can't establish that, then we need to pay payroll tax on that figure.
But can I ask you about having engaged someone in your business for 90 days? Is that, in terms of the way the market operates at the moment, is that a proper test for the purpose of an exemption?
No.
Thank you.
Can I just ask a question before we move on, Mr. Tudor? You're doing that prospectively, but how are you dealing with the liability that you've incurred?
We're going to pay that ourselves.
And what's the quantum of that?
It's a few million. In the case we've had, it'll be about, I think, 15 million across the country.
Ms. Panic, you've heard Mr. White's evidence. Is there anything in that you want to add to or disagree with?
I think in the case of Loan Market, it highlights what the entire mortgage and finance broking industry has been grappling with, which is legislation which is inadvertently court arrangements that mortgage brokers have with their aggregators. As I said in my opening statement, mortgage brokers, they run their own businesses, they're independent. You know, more than 40% of brokers across the country run their own businesses. They do not work for their aggregator. Yet we find ourselves in a situation, because really, I guess the final ruling in the Loan Market case really came down late last year, where brokers in New South Wales and aggregators in New South Wales are now trying to figure out how to apply a law which the view across industry was that it never did apply because of the construct of industry.
No, I accept that. So is it your position that the current Payroll Tax Act is not fit for purpose in terms of giving clear identification about what is a contractor for the purpose of payroll tax?
Yes, it is. And we see the opportunity for the law to be amended to identify what is truly an independent contractor. The intention of the law, as the committee would have heard from other witnesses this morning, the intention of the law was to capture avoidance. These are not businesses seeking to avoid the tax. We see the opportunity for the law to be amended and really to look at how, is services an appropriate test for employment. This morning, Mr. Aquilina mentioned, for example, the concept of control, and is that more of an appropriate test to apply to bring the law back to its original intention. So we would be very supportive and would welcome the opportunity to work with New South Wales Treasury in consultation to have the law amended back to its original intent.
Sorry, Mr. Tudor, there's just one question about in regards
Control.
to this. Yes. You talk about the Loan Market case obviously is a clear marker for this sector. So prior to the case and the decision, was it that there were no audits? Was it that, because we heard different interpretations in other industries, was it that there were different interpretations applied and then this was a shock because it's a new interpretation, which we have had in other cases? Or is it that nothing came up and then this came up?
So if Loan Market approached the association, and this was before my time, flagging this as an issue back in, I think, 2016-17. In 2020, we approached Revenue New South Wales and sought engagement with them to actually clarify that this is the construct of industry and that the relationship between an aggregator and a broker should not be captured under relevant contracts, that these were independent businesses. What we found post that, we spent considerable time working with Revenue New South Wales, that they did not agree with industry's view and issued a CPN, a practice note, saying that mortgage brokers were captured with their relationship with aggregators under relevant contracts. During this time, what we saw is an escalation of audit activity, and I speak on behalf of our aggregator members, where audits started being conducted across a number of aggregators in industry. We saw this very much as a targeted industry approach, which we did not feel was appropriate, because we do not feel that the tax should apply. We continue to work closely with government and Revenue New South Wales.
So could I just, and I've asked this of all of our witnesses today, so working closely with government, you've met with Revenue, you've had those interactions. Did you meet with ministers or ministers' offices about this during that time?
Yes, with the Finance Minister and Revenue New South Wales.
With Finance Minister?
With Minister Houssos over the course of this.
Okay.
In 2022, Revenue New South Wales wrote to the association and notified us that they would hold off conducting any new audits given the significant ambiguity as it related to our industry, because there was no precedent and the loan market matter was proceeding through objection and through litigation. Now, the loan market case is the first where to apply to the facts between an aggregator and a broker, but I do need to bring to the committee's attention that there is another case proceeding through court, and that is Finshaw, where they're objecting to their assessment. I think the reason I highlight that is there's still not clarity for this industry. There's still not clarity for how aggregators should interpret and how Revenue New South Wales is seeking to apply the law to these arrangements.
But just to be clear, these concerns predated loan market, and from 2017, 2016, you had concerns that you were working through either amongst yourselves with Revenue New South Wales, but you didn't approach government until later.
It was really around, there was an initial engagement from government, and again, I can confirm the exact dates because this was prior to my time, around 2017-18.
Yep.
And then there was once I commenced in my role, there was subsequent engagement.
Yeah, if you wouldn't mind, it just is helpful for me.
Also in our submission, we have a timeline from 2023 onwards around the various engagement that we've had with Revenue New South Wales and the Minister's office as well.
So just to be clear, you're asking for, if you could table some of the engagement that you had.
Yes, please, thank you.
We can table all of that.
All of that, that'd be good.
Thank you so much, thank you.
Mr Bushby, you've been very quiet. Have you got anything you'd like to add in relation to the...
Thank you, yes. I think it's fair to say that CAF has been maintaining a bit of a watching brief over the proceedings with LMG since that first started. The specific circumstances around that case relate to consumer lending, and our members are mostly focused on business lending, and there are differences, the differences in the models and how the interrelation between commercial and asset brokers and aggregators work. There are some similarities as well, but there are lots of different models, different ways of doing it. I mentioned, I think, in my opening statement that in some cases lenders directly pay brokers in the commercial and asset space, and it depends to a significant degree on the style of transaction, what assets or what business needs are being financed, how that works. But we've been concerned about potentially regulatory or judicial creep, and through further cases and further or reach of New South Wales Revenue, that they would actually start looking at our relationship as well and decide that that also is caught by the legislation. And indeed, just this week I was talking to one of our members who is a member, is associated with an aggregation firm, but does only probably less than 50% of his loans through the aggregator, and the rest of the work he does on different asset and different business needs, finance needs, he does directly with lenders. But his aggregator and the work that he's done for that aggregator has been assessed by New South Wales Revenue, even though it's only part of what he does. But from the aggregator's perspective, the money that's gone to them has been assessed by New South Wales, and so there's an objection that's gone in with that. So we can see that creep's happening already, even though the models under which asset and commercial finance broking occurs is quite different.
So how many of your members would be subject at the moment potentially to an audit? Not potentially, who are actually?
We have a number of larger firms that are broking firms that would actually be directly impacted because
they're impacted. Are they actually the subject of an audit at the moment? Are you,
well,
to the best of
I'm
your
not.
knowledge?
I'm not aware of. I can't. To the best of my knowledge, I'm not aware of anybody.
Are you aware of how many of your members?
No, and the only parallel arrangement that I'm aware of where one of our members has actually been caught up by payroll tax vis-a-vis the aggregation, the money that's paid to them by aggregators, is the one that I mentioned.
Yeah, I understand.
So that same question to me, we looked at this, I think, a couple of years ago. There are 11 major aggregator groups across Australia, and there was probably 70% of them that were either in litigation, to go to litigation, or an audit. So this is an
8 of the 11.
This is an industry-wide issue.
Yeah.
And I'm assuming that the others are preparing for it as well.
For litigation?
Yeah.
Yes, and I think, that highlights as well just a lack of clarity in the law, and that taxpayers, as with LMG and Mr White, and also in the Finshaw case, need to pursue litigation, which is very costly for themselves and also for the New South Wales taxpayer who funds Revenue New South Wales litigation.
Okay. More from you, the opposition?
I suppose I'm struggling to understand what was the exact turning point or change. Like, at what point did you notice a change? Was it the change when there was a new practice note issued? Did the change happen based on a court ruling, or did it happen when it was simply Revenue? Came knocking on the door saying we're going to do an audit when it came to, in regards to payroll tax, that you thought you never had to pay payroll tax in the past, and it's essentially just a matter of enforcement rather than a change in any regulation or practice note or anything.
I might start with some overarching industry comments. So Mr White referenced the Bridges case, which was in the stockbroking industry, where there is a requirement to hold an AFSL licence. It is our understanding that Revenue New South Wales opined on that and saw similarities between Australian credit licence, the Australian credit licence framework, and saw the opportunity that...
Sorry, just on that, was the Bridges case 2002, did you say?
It was quite a... It was, I don't know the exact date, but it was many, many years ago.
Decades ago?
Decades ago.
I believe it was 2002, Chair.
Yeah.
Wow.
Then we found ourselves in a position in 2015 where a loan market was approached. And then it was brought to our attention, the association's attention probably around 2020, that the Commissioner was looking to issue a practice note, and hence that engagement that I referred to earlier. The practice note, despite our endeavours to consult, was issued really not taking into account any of our observations. And if you read the original practice note, it really looked at the fact that in some instances the aggregator holds a licence and a broker needs to be licensed to provide credit assistance. And in some instances the broker will work as will obtain credit representative status and avail themselves of compliance services that the aggregator offers. Now, I think the thing that's important to note here is that the law, this is a federal law, NCCP, came into place in 2009, and it would appear that for some reason a federal law is giving rise to some sort of employee relationship, which makes absolutely no sense.
So what's the acronym? NCCP?
It's the NCCP, the National Consumer Protection Act.
Dr. Kane.
So with we've had this discussion in previous panels as well. So it's not the broker that's directly being levied, obviously, for payroll tax. They're not meeting those thresholds. It's the aggregator. So it's then a business choice of the aggregator, if they're liable for payroll tax, to pass the costs of that payroll tax down to their. So it's at the bottom of it, whether you agree with it or not, it's a business choice that all aggregators will make based on their business models, based on their margins.
It's not really a choice, with respect. It's 70% of our revenue. So not 70% of our profit, it's of our revenue. So if our profit margin's 20%, the payroll tax is somewhere north of 60%, not of our total revenue. So you just can't be in business and pay 60% of your revenue to the government before you even pay your staff. So it is not a choice. It has to change. Now the only question is, how do you change? Do you levy everybody the same, or do you only do it? Do you say, well, we're not going to employ anyone, we're not going to engage anyone in their business anymore who doesn't employ someone? Do you say sole traders now you're out of business, or do you levy the sole trader for the cost that they're forcing the aggregator to incur by not engaging somebody? So, but I would submit that it is not a choice that we have. We've chosen to not levy the back tax because I think that's un-Australian, but we can't absorb that going forwards. It's just physically impossible. And anyone who says otherwise, I think they're kidding themselves.
The un-Australian part, of course, is a good comment levied at revenue, of course, because they've levied back tax.
Well, I think we're not going to be part of that cycle of unfairness.
And could I just add to that? I think, this is in consumer, which is not really my area, but it has the same impact in terms of business lending as well. The net effect of that will be that those sole traders, a lot of them will not continue in business, and that will actually have an impact on the ability of Australians to access broking services and the competition that puts on lenders to actually keep interest rates down. And the equivalent would also apply if this bleeds into business lending, where it makes it harder for small businesses to get the finance that they need at the price that actually works for them. And there'll be anti-competitive effects on cost of money there as well. Yes. And so it has potential to impact more broadly at a less clear and more opaque way, but quite real.
Just going back, sorry, not to labour this point too much. So the Bridges case happens in 2002. Mm-hmm. If you would ask any mortgage broker in, say, 2014 about payroll tax, they'd say, we don't have to. But say we don't have to pay it. The aggregator, the mortgage broker, even if you ask revenue in 2014, they'd probably say, but then they don't have to pay payroll tax. But then at some point, revenue started enforcing or auditing your industry. Did they give any reason why they started doing that? Why they issued that practice note? Why they? Like, what did they have new legal advice that led to that? Because it's all very confusing.
That is unclear to us, and that might be a question best addressed to Revenue New South Wales for why there was a change in tact many decades after the law was in place.
Yeah, okay. Thank you. There was no CPN issued until 2020?
2020, and then it was reissued in 21 with no update. We weren't aware that it was being reissued, actually.
But prior to us being assessed, there was no case that we were aware of. There was no position on that, and there was no practice note. So this was out of at least for us, it was out of the blue completely.
I mean, from their perspective, when we asked about in budget estimates, it was like nothing's changed. We're just enforcing the law as it is. But the way you're describing it is that there has been a big change from what was previously enforced in the past, and this is what we're going to have to try to get a better understanding from when Revenue New South Wales appears this afternoon.
Yes, and I think if we, as in our submission, and no doubt across many of the submissions that you've seen, on a principle basis, this goes back to the law itself. And in our view, the way that it is drafted very broadly, and in a way that it captures broker aggregator arrangements. And if the intention of the law is not to capture independent businesses, it really needs to be redrafted.
Well, they may not have changed the law, they've just changed their interpretation of it, it seems to be.
And I'm sure Mr Smythe is watching this session. When he comes this afternoon, he will be well versed and prepared for an answer. Because he listens, doesn't he, our Chair?
Yes, Cullen, we're waiting for you. Now, any other questions, colleagues? No? All right, well, we very much hear your concerns. The committee is alive to them, and we very much appreciate the submissions you've made, the evidence you've given today. There was a few matters taken on notice. The Secretariat will be in contact with you in due course to get some answers from you on those matters. Other than that, that concludes the session, and you're free to go. Thank you very much.
Thank you very much.
Thank you very much.
Colleagues, we are now breaking until 2:15 p.m. Committee number 1's inquiry into the Payroll Tax Act 2007. Before we begin, my name is Jeremy Buckingham. I'm the chair of the committee. Could each witness, starting on my left with Mr. Agar, please state your name, position, title, and swear either the oath or affirmation.
Thanks, Chair. Mustafa Agar, Head of Policy at Business New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Ms Greenwood.
Thank you, Chair. My name is Elizabeth Greenwood, Senior Policy Manager, Workers' Compensation, WHS and Regulation. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. Commissioner Frost.
Thank you, Chair. Mark Frost, I'm the Acting New South Wales Small Business Commissioner. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Mr Actestrat.
Luke Actestrat, CEO at COSBOA, the Council of Small Business Organisations Australia. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. Ms Sutton.
Adele Sutton, Head of Policy at COSBOA, the Council of Small Business. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. We'll now turn to some opening statements. Business New South Wales, if you'd like to commence.
Good afternoon, Chair. I begin by acknowledging the traditional owners of the land of which we meet, the Gadigal people of the Eora Nation. Thank you for having Business New South Wales here today to talk about an issue that is equally important as it is frustrating for our members. Business New South Wales represents almost 50,000 businesses of all sizes throughout New South Wales. Every quarter, our members complete our business condition survey. Payroll tax and red tape are a constant and evolving theme, with running a business becoming an increasingly complex situation. For years, we have called for the overhaul, decrease and eventual removal of payroll tax. As a tax on employment, it impacts a business's ability to grow and thrive in New South Wales. Our economy has experienced significant inflation over the last 3 to 4 years, resulting in bracket creep within the payroll tax regime. This means more businesses are participating in a scheme, which we outline in our submission, is complex, uncertain, and is a fair way away from its original intended purposes in 1927 and later 1941. To the direct terms of references of this inquiry, Business New South Wales opposes the application of payroll tax on truly independent contracting arrangements. The provisions that are currently contained in the Payroll Tax Act exceed the original anti-avoidance intent, unfairly capturing genuine independent contractors and intermediaries who explicitly do not choose an employment relationship for commercial reasons. Further, retrospective tax application and inconsistent interpretations by Revenue New South Wales has created significant uncertainty and administrative burden, inhibiting investment and growth. Business New South Wales recommends urgent reform, and we look forward to responding to questions throughout today's session.
Thank you very much. Mr Frost.
Thank you, Chair. I thank the committee for the opportunity to make a submission and provide evidence today. A key objective of the Commission is to promote a fair operating environment in which small businesses can flourish. With this in mind, the Commission has been closely following industry concerns regarding the application of the Payroll Tax Act to arrangements commonly used by small businesses across various sectors. As the committee has heard today, many small business stakeholders are concerned that payments made to them may be subject to payroll tax despite operating as independent businesses under genuine commercial arrangements. While most small businesses are not directly liable for payroll tax, some are, and under the contractor provisions of the Payroll Tax Act, small businesses can find themselves indirectly bearing the cost of payroll tax. While it is important for there to be appropriate safeguards to protect against tax avoidance schemes, the Commission would welcome a legislative review of the contractor and employment agent provisions to ensure they are fit for purpose for our modern economy. This includes ensuring non-employing and micro businesses are not systemically disadvantaged and making sure our tax system does not impact arrangements which exist to improve efficiency rather than to avoid a tax liability. Thank you again for the opportunity to contribute.
Thank you very much. The Council of Small Business Organisations.
Thanks, Chair.
Mr Actestrat, fire away.
Thank you. If you want less of something, tax it more. The New South Wales Government will bring in almost $55 billion in payroll tax over the next 4 years. Remarkably, this state will raise more in payroll tax than gambling tax. This inquiry is timely.
An alarming symptom of the New South Wales payroll tax addiction has been the reckless mission creep of its application beyond the employment relationship. Payroll tax was never intended to be payable in a B2B relationship. Yet small businesses have been highly anxious since a court ruling harshly found a business providing services to mortgage brokers somehow owed payroll tax. Even the judge in that decision acknowledged the harshness of that case. COSBOA stands firmly with MFAA, CAFBA and Australian brokers who are critical enablers of enterprise and small business success in New South Wales. Without change, the average self-employed broker is set to lose $68,000 or a third of their gross income. This will reduce competition and push up borrowing costs for New South Wales residents. But of course, COSBOA represents an array of small businesses, not only brokers, and there are huge concerns of contagion beyond the broking sector. In fact, various sectors from direct selling, logistics, cleaning, as you've heard earlier, and agriculture are all highly anxious. Small business confidence in New South Wales is already low, currently sitting at 25%, the worst result in over a year. At a COSBOA summit last year, Premier Chris Minns told small businesses, if poorly designed taxes are weighing down small businesses, we want to cut these wherever we can. Let me just read that to you again. If poorly designed taxes are weighing down small business, we want to cut these wherever we can. It is clear the government knows we have a problem here, evidenced by its decision to exempt general practitioners trading as small businesses. However, the law needs to be changed and clarified to ensure it is fit for purpose for all and that bona fide contractor relationships are not wrongly captured by payroll tax.
Thank you very much. We'll now turn to questions from the committee, starting with the opposition.
Thank
Mr. Tudor.
Chair, thank you very much for the very good quality submissions which you've made. Can I just start with you, Mr. Frost? You're the Small Business Commissioner. Have you, or the Acting Small Business Commissioner, have you made representations to the Commissioner for Revenue New South Wales in relation to this issue?
So I'm aware there may have been some discussions under the previous Small Business Commissioner. I'm not specifically across the nature of what those might have been. However, I'm also conscious that during the last several years, some of this has been contingent on court decisions, some of which may remain unresolved.
So, just so a lot of the evidence that we have heard relates to a number of issues have arisen. The first is the lack of clarity which is contained within the Payroll Tax Act relating to what an independent contractor is for the purposes of payroll tax. Secondly, the issue of retrospectivity in respect of assessments by the Commissioner. And thirdly, potential penalties. I'm going to go to the first of those. The first is relating to the actual framework and the way the Act is structured. Is it the Small Business Commissioner's position that the Payroll Tax Act needs rewriting?
So I think what I would say to that is that it would be a good opportunity to have a look, get the best tax policy experts together to have a look at what arrangements under the Act would address some of the issues that have been raised both in the submissions received by this inquiry, but certainly in terms of the small businesses that may find themselves liable for payroll tax, maybe perhaps not directly, but certainly indirectly, to examine if that's indeed matches the intent of the current contractor provisions of the Act.
You would have read, I think one of you referenced the loan markets case and the observations made by the judge in that case. Is there not a case for rewriting this Act?
I think that should certainly form part of consideration under a review. I mean, that's certainly what we've called for in our submission. If that allows an opportunity for all the different potential opportunities to alternative approaches, consider alternative approaches, I think that would be worth doing, and there's a merit in doing so.
Mr. Ogo, is that your position, that this needs rewriting?
I'll defer to my colleague, Ms Greenwood.
I think our preferred position is that it not exist at all.
Well,
and
you
everyone
and I can
goes
agree
back,
on that, but
goes back to the drawing board. I would agree. It seems to be a problem, especially when you read the most recent cases, that a lot of them didn't reach appeal because there was no error of law. And the reason why there was no error of law was because the decision based on statutory interpretation was correct. So to the extent that payroll tax needs to avoid having, quote, unintended consequences, yes, it would need a rewrite. However, I think the bigger picture question is, what is the payroll tax for? It originally was to subsidise a child endowment scheme, and it was supposed to be regarded by businesses as being a depreciation on labour, similarly to depreciation on plant and equipment. That is no longer the reason for the payroll tax to exist. So I think there's very much a fundamental question: why do we have it? Obviously, it's an incredibly important source of revenue, but why does the revenue have to flow in that way, given it's so harmful?
I think it was child endowment was one part of it, but it was holiday pay and other things. So, just in terms of the specific issue which with this inquiry relates to independent contractors. Now, I'm sure you had opportunity of reviewing the provisions contained in the Act. Every piece of evidence we have heard so far is that there is lack of clarity around those provisions, and people who have been given clear audits are now being, in fact, assessed. Would that indicate to you that these provisions are no longer fit for purpose?
They're not fit for purpose if they're still trying to adhere to the original object of being anti-avoidance provisions from back in the mid-80s, when a contractual arrangement with an individual went from being an employment arrangement to a contracting arrangement. If that is still the purpose, then it clearly needs a rewrite. However, I think it needs more than a rewrite, it needs a review.
Well, perhaps that's a discussion for another day, and you and I can be on the same page in relation to that. But I'm just, for the specific purposes of this inquiry, where you've heard the evidence and seen the submissions which have been made in relation to the manner in which companies are now and aggregators are being assessed for land tax, for payroll tax, in circumstances where they've never been assessed before. Is that a circumstance which would give rise, in your mind, to a necessity to rewrite these provisions?
I think, to the extent that there is uncertainty in the business world, it's very much a very poorly drafted piece of legislation. It still gets back to the question, why is it there?
You can rewrite anti-avoidance provisions if, in fact, you want to capture anti-avoidance. But if this is creating circumstances where businesses, small businesses, large businesses, are now receiving very large land tax bills, is not that an indication that this legislation is not carrying out the purpose for which it was intended?
I think you misspoke then, Mr. Tudor. I think you said land tax.
No, payroll tax.
Payroll tax.
Payroll tax.
Well, maybe you can help me understand your question. What do you say the purpose of this tax is? Because originally it was a tax on wages, and I recall reading somewhere that there was an amendment made where a particular entity, their wages were exempt. So I'm a bit unclear as to what the purpose is supposed to be.
Is it not your understanding why you're here today is to, in fact, give evidence in respect of the manner in which payroll tax is being assessed on independent contractors?
It is the effect of the provisions is why we're here.
Yeah. And
well, I believe I've answered your question.
That it's not fit for purpose?
Yes.
Yes. What's your view, Mr. Ackerstrom?
It's not fit for purpose. It needs a rewrite. Next question.
I think it is to the extent that there are small businesses which are in fact now caught, which have never been caught before, in circumstances where they have received audits in the past which have given them clean bills of health and are now being assessed and are being the subject of retrospective tax together with penalties. Does that give rise in your mind to a circumstances where the provisions relating to independent contractors are no longer serving their purpose?
100%.
Have you ever had any contact with the Commissioner for State Revenue in relation to this?
Yes, we have.
And enlighten us to what those conversations, how they have gone in respect of his view in respect of these provisions.
So I think the provisions are broad, they're very ambiguous, and that's partly why we are calling on legislative certainty and legislative change to enact what I called in my opening, making sure that the provisions are fit for purpose. Look, we've engaged with the Minister for Finance, the Minister for Small Business, we've engaged with Revenue New South Wales. I think I would describe that interaction as Revenue New South Wales taking the view that they're not policy makers, they are policy implementers.
Yes.
So effectively being told this is the law of the land. So I know their witnesses later on today, so I'm sure they can speak for themselves, but we have had ongoing contact with New South Wales Government and all sides of Parliament to really put forward how this is having a terrible impact on small business. This is having a huge impact on competition, a direct financial cost to small businesses who are legitimate bona fide independent contractors. And the examples we have go beyond what you heard earlier in terms of broking. We have an example, my colleague Ms Sutton might elaborate on this, a business person who bought a direct selling entity, and in the process of doing the due diligence and when that transaction went through, discovered that there was actually a hidden liability of payroll tax, which had not been, forthcoming due to the uncertainty and the ambiguity of what we're talking with here. So this is affecting confidence. It's already had a big impact. The anxiety that I talked about amongst small businesses.
So the value of that business was then correspondingly diminished?
Correct.
Tell us a bit more about that, Ms. Sutton.
So in my previous role, I was the head of legal and policy at Direct Selling Australia, and there's particular nuances in that industry in the fact
For
that...
which industry again?
And the direct selling industry, so you think of Tupperware or Avon back in the day. And so there was a lot of anxiety, and continues to be within the industry, when an exemption was removed, a door-to-door sales exemption. And my understanding is there had been, outside of the industry, an instance of sham contracting, which was the policy lever in removing it. But as an inadvertent consequence then in New South Wales, not in other states, that exemption that the industry relied on was removed, and subsequent to that there's been a lot of uncertainty, and I think there was a direct selling company that made a submission which outlined just the sheer quantities in terms of liability and penalties, and $400,000 in legal fees in addressing the liability that until that point they didn't realise that they had.
Do you recall the name of that case?
That's USANA.
Which one?
USANA. And so a lot of these companies, sometimes they're international, and They have independent contractors. There's something like 350,000 independent contractors across Australia. I don't have the specific figures for New South Wales, but 78% of them are women, usually looking to make a couple of $100 extra a month, supplementary income, and then this extra 5.6% for the companies that are liable to pay it. They just take that out of their commissions, so it's literally like putting their hand in their pocket.
When did you first become aware that this was an issue?
Well, I started in that role in 2018, and at that point the exemption had already been removed, but there was some interactions then with Revenue New South Wales, because the commission's really on the products sold and there's no way of telling what time is spent in terms of, they are very flexible, they're very independent, they don't put in timesheets, there's no invoices, so there's no way of understanding how much time they spend in their business. It's very much just commission paid on product, and so there was lots of conversations about how on earth each company could work out their liability, and in terms of the replacement method. I'd not been involved in payroll tax before I started that role, and it was completely baffling trying to understand the provisions and then explain them to the industry.
So, Mr. Acklestrack, obviously you haven't been in the role for a long period of time, but on your examination of the records of COSBOA, it's not only in relation to the direct selling industry, but when did it first come to the notice of COSBOA, the members, that they were being impacted by this?
Well, it probably actually originally came through direct selling, and Ms Sutton, when she was in that role, talking to COSBOA in relation to that matter. Obviously, the loan market case had a big impact too, and COSBOA, as I mentioned in my opening, proudly work and represent MFAA and CAFBA. Yep. So we've had quite a few different of our member organisations noting, as a peak of peak, COSBOA comprises almost 50-odd small business organisations. But probably also, Mr Tudor-Hope, not just particular member organisations, but as Ms Sutton alludes to, practitioners, tax practitioners, organisations like CPA, the Institute of Certified Bookkeepers, people who are expected to give advice about this stuff, find it pretty difficult to do so. And that comes at additional cost to them, themselves being small businesses, but it also inserts a lot of operating uncertainty onto people who are trying to run their business. The example Ms Sutton gives about independent contractors who might largely be women looking to, during a cost of living crisis, sell some product, create some social events, and that they're having their take-home pay potentially undermined by the imposition of payroll tax. For me, that is a huge issue where you can actually see the human impact of what we're talking about here. But certainly the professional services side of things as well, where people are trying to interpret these legal cases. And how do you interpret and explain a legal case to a small business where the judge themselves has admitted it's extremely harsh? It beggars belief how the average punter out there can understand how that is in any way, shape or form fit for purpose.
So, and in relation to Business New South Wales, when did it first become an issue with your member organisations, or when were you put on notice that Revenue was pursuing potential payroll tax audits in respect of your members in circumstances where they were never potentially liable for payroll tax before but are now liable for payroll tax now?
We might take that one on notice and come back to you with a supplementary on that, look through our records. The issues popped up here and there over the years in different ways. It's one of those ones where our members keep complaining to us about the complexity of the regulatory environment. We keep seeing comments come through about being pursued for payroll tax and other issues, but we can take that on notice, come back with a supplementary submission on that. What we're also seeing is our member businesses, especially small businesses, are finding the regulatory environment more complex. This is one of those areas impacting that as well. It's harder to navigate, the clarity isn't there, and where advice is given, they're often told this is a likely outcome, but we can't guarantee anything. When businesses are operating in their environment, it's really difficult to grow, to invest, and often businesses are finding themselves capping themselves at a certain size to kind of avoid these issues as well.
Have you had any meetings or correspondence with the Commissioner for State Revenue, or Commissioner from New South Wales Revenue Commissioner, in relation to this issue?
Not to my knowledge, but if there's any meetings that I can look into, we'll come back with that as well.
Have you had any meetings with members of the government in relation to this issue?
Not specifically around this contractor arrangement, but around payroll tax more generally. We've continued to advocate on that.
to abolish it?
Abolish, reduce regional payroll tax. There's a whole bunch of provisions that we think will create a more effective tax system that encourages investment and encourages investment in New South Wales.
In fact, I think one of your submissions is that you suggest that the payroll tax threshold ought to be increased.
Inflation has had a significant impact on businesses. That threshold needs to continue to match that, either through CPI, WPI or other arrangements that will allow our businesses to continue to grow. I think there was an article this week just looking at the cost of trade going up. Some wages are going up 20% a year, 15% a year. There's bracket creep taking place there. That needs to keep up with the times.
Did you just say regional payroll tax?
Regional payroll tax, yeah.
What's regional payroll tax?
So Victoria has a regional payroll tax. So we have border communities like Albury who are like investment decisions come down to Albury or Wodonga. The regional payroll tax, I believe, is 1.21% in Victoria. We think that should be matched. People shouldn't choose to invest based on payroll tax in New South Wales. That's a real perverse outcome that's taking place in our regions.
Question. Did you say in some places wages have gone up 20%?
There are industries where they're saying there's some kind of key industries. I think construction's one of them where things are going up significantly.
The wages component by 20%.
There is it's double digit. I'll have to come back to you on that, but it's a significant growth year on year, especially when it comes. I think there was an article this week around the $250,000 a year trade is. So there's some key areas. We have a housing kind of crisis. There's significant demand on
Tradies who are independent contractors.
Depending on how they're arranged. Yeah.
Do you think, just on the threshold, this is probably to all of you, but is there enough clarity when businesses hit the threshold mark, so they may have been under the threshold for years, their labour costs have increased, their payroll has increased. How have you found the guidance from Revenue New South Wales in terms of the communication from them to small businesses that once they hit the, 1.2 million or whatever the threshold is? How's that?
I can't comment on how the communication is done. I think we can have some conversations.
Isn't it self-assessment for the individual businesses?
Yeah, but I'm not sure if there's any communication that's triggered once there's kind of anything put into single payroll touch or other
So they
systems.
don't get a notice saying you're at 1.1 million payroll.
Watch out.
Are you aware that next year you might be eligible? You might have to, be liable for. So there's no full warning potentially, because that's something I've heard.
I pay payroll tax. You don't get that.
There's no.
Anytime you get a notice, I'm answering your question for you. Anytime you get that is when either the threshold is going to go up or the rate of tax is going to go up.
Mr. Rath, that level of customer service unfortunately does not exist in the current operation of Revenue New South Wales.
They just come when they want money.
Well, it's kind of their job.
Exactly.
Send you an email.
Yeah.
Dr. Kane.
Mr. Agar, I think Mr. Tudor asked you about engagement with government, and just to be clear, across the years. So this is an issue that we've heard today is one that's long term and it's been an issue for a while. So you've obviously engaged with Revenue New South Wales. Have you?
No, not specifically on independent contracting arrangements that I'm aware of.
But just on payroll tax generally. Just on payroll tax generally.
More generally.
Okay.
Our advocacy has been around payroll tax as a general principle.
Okay, but you have or you haven't engaged across a range of years with government ministers' offices? You have or you haven't?
On payroll tax generally?
Yes.
Yep, I believe so.
Okay.
Yep.
Would you mind providing us with information about when that might have been?
Yeah, we can look at see what we can provide you.
This minister, previous ministers?
Sure, we can see what we can provide from our records.
Thank you.
So if you're going to make have you turned your mind if you were going to make changes to this Act, besides abolishing the Act? So if we're just going to make changes, what they would look like?
If I could get back to clarity around the purpose. Your question, Dr. Kane, about engaging with Revenue New South Wales in a former role I had with Housing Industry Association. I used to have quarterly meetings with the then Commissioner and his three. Each one was in charge of payroll tax, land tax. Payroll tax, land tax, and there was a third one. Duties.
Duties, yes.
Yep.
Stamp duty.
Yep. And I recall at the time, this was just prior to the harmonisation, they were trying to harmonise, and I remember Commissioner Smith saying to me, look Liz, what we really need to do is have a test for who dependent contractors are. That's what he said back prior to 2007. It's unclear whether that is still the purpose, given that now wages paid to employees, I can't recall what the entity is, but wages paid to employees are now specifically excluded. So I think the question is, what is the purpose? Then examine the provisions, and then you have a better idea of how it should be changed, if that is indeed the appropriate way to go.
Is that your view about how you would change the Act other than abolish it, Mr. Oakerstreet?
I might defer that to Ms Sutton, given her strong legal background, Mr Tudor.
Not in tax. Well, I think probably the interesting part about it is the fact that it is a self-assessment regime. So anything, especially for small businesses, you've got to assess your liability. It needs to be easier, much easier to understand. There's so many parts to it and exemptions to it. It's far too complicated and far too broad. So it needs to be a lot simpler. So in that respect, we think it'd be an opportune time to have a consultation as to work out how to simplify it, and also create specific and workable exemptions so that the contractor provisions are fit for purpose and that they don't capture bona fide contractor arrangements, particularly as they currently stand. This reference to deemed wages, it doesn't really align with how the ATO views contracting arrangements, and also the use of ABNs. I mean, taking the direct selling example, again, the page that Revenue New South Wales have implemented, which they didn't consult industry with, it just doesn't, the examples just don't reflect the reality of the industry. So I think also there needs to be more consultation with the industries affected as to how that simplification process could be reached.
That's an excellent answer. I've got nothing further.
Look, my apologies, you might have said this at the beginning, but we're getting a lot of, I just want to clarify. Mr. Oakerstreet, of your membership, what's the proportion that this impacts?
This would impact a significant proportion. Taking alone direct selling, who Ms Sutton's mentioned, there's about 250,000 independent contractors operating in direct selling.
About 350, yeah.
So of the 50-odd member organisations we represent, I would suggest we have had conversations with respect to this issue with between 5 to 10 of those member organisations.
Okay,
so it's not insignificant.
But it's the member organisations that are ones that are liable for the tax, not the independent contractors.
Sorry, for clarity, a member organisation for us could be Direct Selling Australia, it could be Master Builders Australia, it could be the Australian Retailers Association. We're a peak of peak organisations.
Okay, thank you. That's helpful.
Helpful to clarify.
Yeah, okay.
But I think what
supply chain of membership there, yes.
Yeah, you might be hitting on in terms of who actually pays the damn thing. It is obviously the head entity in that respect, but as we've heard the evidence about that payroll tax being passed on to small businesses, and as such why we're here and have such a keen interest in the work of the inquiry. And
Mr Frost, again, forgive me if you've covered this already, but in terms of all of your work, how much what's this in terms of the priority of the conversations you have with small businesses? This particular issue, payroll tax generally, and then these particular issues.
Sure. So we would not be the natural place within government for a small business with an issue with their tax affairs to contact. Sure. So it's not our bread and butter. Yep. However, we do engage with small businesses proactively to understand the nature of their concerns. When through our insights initiatives and programs that we have, we do seek intelligence from the small business sector to better understand the nature of this. We find that about of those who are involved in payroll tax and administering payroll tax, about a quarter of those respondents to that survey question that we put out, and that is referenced in our submission, indicated they did have challenges with applying and determining the contractor provisions of the Payroll Tax Act. So you can extrapolate that across the broader economy, and it's a fairly significant issue.
Okay, thank you. Thank you, Chair.
Well, thank you very much, everyone, for coming and giving evidence. We very much appreciate it, and also your excellent submissions. The committee is hearing the concerns of you and the other stakeholders loud and clear. We, through the Secretariat, will be in contact in due course on those few matters that were taken on notice. But again, thank you very much for the work you do, and you're free to go.
Thank you, Chair.
Dismissed. Thank you very much for attendance and your submission. Before we kick off, of course, we have to get you to state your name, the position, title, and for you to swear either the oath or affirmation. I'll start with you, Mr. Smythe.
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God. Cullen Smythe, Commissioner of State Revenue.
Thank you.
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God. Scott Johnston, Chief Commissioner of State Revenue.
No worries. Thank you very much, Mr. Johnson. Does Revenue New South Wales want to make an introductory statement?
Yes, I do.
Okay, fire away.
Sorry?
We are only the enforcers, we are not the policy makers.
It may contain something to that. Thank you to the Select Committee for the invitation to make a submission to the inquiry and to attend this hearing to give evidence. Let me begin by saying that Revenue New South Wales is responsible for administering the state's taxation laws.
Wow.
We administer those laws as written fairly and impartially. While we assist the government in reviewing those laws and developing any changes, we're ultimately not responsible for tax policy. Tax policy is led by the Treasurer and the Treasury and is shaped by a broad range of economic, social and political considerations, which is beyond our remit to comment on. Therefore, to the extent that the Select Committee is investigating possible legislative changes, we're constrained in what we can say. I'll now make a few observations on key points drawing on the submission that we provided.
Sure.
Firstly, it's worthwhile putting the discussion around the application of contractor and employment agent provisions in some context. In the last financial year, 19% of payroll tax customers reported contractor payments and 2.7% reported having an employment agency arrangement. Of the 19% of customers that reported contractor payments, 40% claimed an exemption. The total taxable contractor payments average, $5.2 billion per year, represents only 2.1% of the total gross New South Wales wages paid. In the last financial year, Revenue New South Wales conducted a total of 3,452 payroll tax audits. Of these, 1,477 resulted in no further action, which is 42.8%, and 62 resulted in refunds. Of the payroll tax audits conducted, 14.6% found underpaid payroll tax relating to contractor payments that did not qualify for an exemption, and 2% found underpaid payroll tax related to employment agent arrangements. Based on these figures and our experience, businesses are generally aware of the contractor and employment agent provisions and how to apply them correctly. Secondly, I'd like to say something about the Payroll Tax Act 2007 and the provisions relating to contractors and employment agents. Payroll tax was first introduced in 1941 by the Commonwealth Government and then transferred to states and territories in 1971. Since that time, the policy underpinning the tax has remained largely intact. That is, it's a tax on remuneration paid to workers who are employees or who, for all intents and purposes, are in an employment-like relationship with a business. By employment-like, I mean an arrangement which has a resemblance to an employer-employee relationship, where workers are procured to work for a business and obtain income from that work. The contractor and employment agent provisions were introduced in 1986 and 1985 respectively to the Payroll Tax Act 1971, which preceded the current Act. In an environment where contractors were increasingly being used in place of common law employees and employment agents in place of directly engaging workers, these changes in how businesses procure labour have occurred and continue to occur within a broad context of commercial influences, including but not limited to tax considerations, and is something that we continue to see evolve today. In relation to contractors, the broad policy intent of the payroll tax legislation is given effect by making wages paid to contractors liable to payroll tax unless one or more exemptions apply. In general, these exemptions cover circumstances which suggest that the contractor is in a non-employment-like relationship with the employer. For example, where the contractor's services for the employer are of a limited or transient nature or incidental to the activities of the business. In relation to employment agents, the provisions apply when there is an employment agent contract where the workers procured by the agent work in and for the client's business in much the same way as the worker was the client's employee. In these circumstances, the Act deems the agent liable for payroll tax on wages paid to the workers. For both contractor and employment agent provisions, what is paramount is a consideration of all the relevant facts and circumstances of the relationships between the parties and whether they fall within those provisions as written, as I've just outlined. Contrary to the assertions made in some submissions to this inquiry, there has been no major change to the contractor employment agent provisions, nor the introduction of any new tax. Some submissions to this inquiry also suggest that the provisions were intended to tackle tax avoidance schemes set up to disguise an employer-employee relationship. However, while addressing tax avoidance may well have been one motivating factor for their introduction, it's not correct to construe the purpose and application of the provisions in such a narrow way. There's nothing in the provisions themselves that requires that a particular labour arrangement be intended to avoid tax in order to trigger their application. Thirdly, having outlined the provisions, let me just say something briefly about our approach to administering those provisions and payroll tax generally. Liability for payroll tax is imposed by the legislation. Payroll tax is a self-assessed tax, and our focus is very much on the voluntary compliance from the outset. We encourage and assist taxpayers to comply with the law by providing a significant amount of information, education and tools to help them understand their obligations. Revenue New South Wales issues revenue rulings and Commissioners' practice notes, which provide detailed guidance on the interpretation of the provisions within the Act, including practical examples. We often develop these in consultation with our key stakeholder committees, which include representatives from the Tax Institute, the Law Society and other bodies. This ensures that guidance we provide is clear and useful for the taxpayers and professionals that we're working with. Our submission listed the various publications that we've issued specifically in respect of the contractor employment agent provisions. And as with all taxes, Revenue New South Wales undertakes compliance activity. We take a risk-based approach that concentrates on high areas of risk using data analytics and risk assessment processes. Audits ensure that taxpayers are self-assessing correctly in accordance with the law and that there's a level playing field for all. If an audit identifies that tax has not been correctly assessed and there has been an underpayment of tax, Revenue New South Wales may issue a reassessment. This may be for multiple tax years if the underpayment has occurred for such time. It may be issued up to 5 years after the initial assessment was made. It may also be longer in certain circumstances. It is in this context that I must respectfully reject the assertion made in some of the submissions to this inquiry that Revenue New South Wales has retrospectively imposed liabilities on taxpayers. This is simply incorrect. As I stated earlier, liability is imposed by the Act. Where we have issued a reassessment for multiple years, this is because the taxpayer has, for some years, incorrectly assessed their liabilities and underpaid their payroll tax. And this is only identified by us at a later time. During the audit process, we work with the taxpayer to understand why and how the underpayment occurred. This does not derogate from the existence of the liability that is payable under the law. As with any government administrator, our decisions are subject to review by the courts, and there have been a number of court decisions that have considered the application of contractor employment agent provisions in different contexts. This is to be expected given the breadth of industries that employ and the various and emerging models of employment that as the market evolves. However, consistently and over time, the courts have affirmed Revenue New South Wales' interpretation and application of the law to the facts of the case. None of these cases resulted in new taxes or changed who is liable for tax under the law, which, as I stated earlier, has remained largely unchanged for decades. Regardless, Revenue recognises that the issuing of reassessments of payroll tax liabilities for multiple years can place significant and unexpected burden on a taxpayer. As with other taxes, we support and work with taxpayers who may have difficulty in meeting their obligations, and we encourage them to contact our office to discuss options which can include extended time to pay or payment by instalment. And lastly, as we point out in our submission, New South Wales operates within a harmonised payroll tax regime that was one of a number of initiatives sponsored by the Council of Australian Governments to reduce red tape and drive productivity. If any legislative amendments to address issues arising out of this inquiry are to be pursued, consultation with other participant jurisdictions will need to be undertaken and their agreement obtained in order to maintain harmonisation. Any significant shift away from the harmonised regime may increase costs for businesses operating across jurisdictions. Mr Buckingham, that concludes my opening statement.
Thank you very much, Chief Commissioner. We will now turn to some questions. Mr Tudor-Hope.
I'll go, Chair.
Oh, you'll go
if
first.
That's okay.
Mr.
Yep.
Rupp, sorry.
Thank you both for attending today and for your submission, and also for your appearance at budget estimates as well. I don't know if you had a chance to listen to the evidence given today from the mortgage broker panel.
No.
Okay. So I'll go into a little bit of detail. So they basically say that there was the Bridges case in 2002. I assume you're both aware of that. But that the first time that they've been essentially assessed or hit with a payroll tax bill was around 2016. The Bridges case was in about 2002. Is the payroll tax liability that that they've been assessed as having to pay, does that stem from the Bridges case in 2002? Is that the interpretation that Revenue New South Wales is using?
So I'll make a broad comment, and perhaps Commissioner Smythe might build further. So importantly, as I've outlined, payroll tax is based on self-assessment. Our audit program is based on assessment of risk factors where we undertake audits where we, through data analysis, have a sense that it's worthy of auditing in a certain space. So without speaking to specifics, but I've said the law has remained fairly consistent over this time.
Yeah.
When a particular business comes to our attention, that would be based on our audit and compliance program, which we can't audit and don't audit every business in existence. So it would make no reflection on what happened between 2002 and up to the point of time where we might have engaged with them. But the law would have been consistently held, and the expectation is every business that is subject to payroll tax does it in accordance with the law.
So Mr. Smythe, did you want to add to that?
No.
Okay. You looked like you wanted to. So you're saying then that it's not. And you said in your opening statement that the law hasn't changed, the provisions haven't changed, the tax hasn't changed, but a lot of the submissions and the witnesses we've heard from have felt like it's changed at least, or that they feel like they're needing to pay payroll tax now where they previously haven't. You're saying that in essence that's because they were self-assessing in the past and self-assessing that they didn't have to pay payroll tax, but now your audit process of recent years has determined that they haven't been essentially self-assessing it correctly. So there's a discrepancy between their self-assessment and your audit, and that's really what the essence of it is.
That might be one of many factors why they've come to attention, including business models changing and other contexts, but potentially the point to the first question, that could be the case for many businesses.
Yeah, jump in, yeah.
Has there been something, because we're just puzzling with the evidence that we've received today. Has there been something that's changed? You mentioned data analytics as informing the decisions you're making. Was there a point of time or several points in time when your audit processes have changed, where your audit identification has changed, where you're using a different data analytics tool? I'm just wondering if there's something else that might have precipitated this change.
So probably a general response would be that our analytic capability, our access to information would have improved significantly over time, and so our ability to be effective in our compliance effort has increased. But as I mentioned in my statement, nearly half the audits that we undertake don't result in a reassessment. I think the other, reflecting on coming here today, the other changes that we've seen in the last 5 years at least is there was a long period during COVID where we paused our audit program. That was out of so many other things were happening at that time, and that auditing businesses wouldn't have been appropriate. We haven't tried to catch up following that, but there was a period of lower effort and lower compliance that we did for a couple of years there that is now back to normal levels.
I guess so. You must have a way of triaging or determining priority sectors. Is there something that might be there that?
So what we have evolved over recent years is this risk-based approach to auditing rather than a random approach. So this is where we do have access to other information that speaks potentially to industries where there might be compliance issues or areas to explore that then focuses our compliance officers in that space. Because ultimately our objective is to administer the law fairly and equally. And so the motivation to that is where we understand most businesses are meeting their payroll tax obligations as the law is, but having the integrity in the system requires us to assess that. And so that is an area of focus for us, but it's not driving particular targets at any industries for any other reason other than data and information we might have suggests there might be reasons to explore the compliance orders.
Could you indulge me for one more on that line? In terms of that risk-based assessment, are you able, I don't know if you are, but are you able to share what the sort of attributes are of risk that you prioritise? I don't know
I'll
if you're
take
able
that
to
on
share
notice just to think about how can we best help you, because I think that's a useful point. Maybe the factors that we consider in developing that to a point. It's fairly broad, but it happy to
might be helpful.
work it in the way that we could help.
Thank you.
The practice notes that you issue, are they informed by legal advice? Like, have you received new legal advice in the practice notes that you've issued to the mortgage brokers, for instance?
Could I? So there are a number of lawyers who work at Revenue New South Wales. I'm one of them, and I sign off the bottom of the Commissioner practice notes. They're not meant to be a determination like, say, a revenue ruling or a specific legal advice. It'd be helpful, I think, if you have a moment, just to go through the three major parts of communication or advice material that we provide to taxpayers across the state. The first is the more general information that we make available on the website. We try and provide both guidance to specific provisions and cases. There are case summaries, case notes, all of those sorts of things that try and take what can be, I think I mentioned in estimates, the tax law itself is generally not overly complicated. It's trying to match that to what it is, a very rapidly changing set of business circumstances. So that's one. The second item in the hierarchy is revenue rulings. Revenue rulings are generally issued under this harmonised regime we have with the other jurisdictions, and they touch on specific points in the legislation, try and clarify them, make references to specific notes, specific cases when that's appropriate, and deal with more complex issues. Practice notes are something different. They had their genesis really in New South Wales as part of a response to queries on a number of our taxes around how do you actually administer them. I can read the cases, I can read the legislation. What does that mean for particular industries? And that's why you will see practice notes being issued in industries where we've had particular questions. So financial services, mortgage aggregators, medical centres. They're not meant to be a pronouncement of new law or new policy. It's basically saying this is...
Nor a new interpretation of the law.
That's...
Nor a new interpretation of the existing law.
That's correct. And they're replete with examples. So we try and make points and then show how we would apply those in various scenarios. I think it was Mr. Aquilina in this morning's testimony. I did manage to see some of the hearing through the day. He pointed out one of the difficulties with practice notes, which is we can only provide a certain number of examples, but the possibilities of different business models and transactions is this large. So I acknowledge that their utility for some business models may well be limited, but that's where they are meant and the examples are chosen to try and give a flavour of how we administer. And then, of course, there is the option for particular operators to seek a private ruling on their individual circumstances.
Just going back to the mortgage brokers, so the evidence that we heard was that at some point after 2002 with the Bridges case, probably and 2016 or at some point thereafter, I think maybe it was 2020, that there was a new practice note that specifically came out to that impacted them. What information led you to come up with that practice note specifically for mortgage brokers? Was it there was a lack of clarity in that industry that required it?
I'm not sure I'd say there was a lack of clarity, particularly for that industry. We had received a number of questions for the financial services industry, and we were engaging with the mortgage aggregation bodies that had raised a number of questions. There was also the process of commenting on the administration of payroll tax under the former government. There was a focus on trying to ensure that there was sufficient general information available to taxpayers who might be liable to the different taxes we administer. Of course, given that the legislation is a self-assessment legislation, the primary responsibility is on the individual taxpayers to consider their business model and the way that the law applies to that. The vast majority, as the Chief Commissioner mentioned, do that successfully. Most businesses have both financial and legal advisors who are able to provide them with advice. Our efforts in that area were focused on making sure people were aware not just of the law, but of how we administer that practically. And also what sort of evidence we would expect to see if someone was making a lodgement or was subject to an audit.
Yeah, okay. But trying to get, I suppose if we went back, say 10 years ago, the amount of revenue from payroll tax that you would have received from the broking aggregator type businesses compared to how much revenue, your payroll tax revenue from that same industry you're receiving today or expecting to receive once they pay their liability would be vastly different. It would be close to zero, I would assume, back 10 years ago, and it would be quite substantial today.
So I think it's hard to answer that question with any confidence in terms of the numbers, because I haven't got what we were doing 10 years ago in front of me. But I think that the essence of what, so that may well be true. So I think that's, but it doesn't mean a liability did not exist.
It was just unpaid.
Potentially, and not.
But they didn't assume they had to pay it. They were under the assumption back then that they weren't liable for that payroll tax that they now are. That's the point of contention, right? You're saying they've always been liable, but it wasn't enforced through an audit.
Has remained consistent. So if everything else has stayed the same, and a business is now found liable, it's very likely that, and there's a lot of factors that come into a payroll tax assessment, including the business model outside of the law, such as the models that they're employing. But if everything else stayed the same, it's conceivable, yes, that there was a liability 10 years ago that wasn't pursued. I think the point that Commissioner Smythe was just making about the engagement, there was not a trigger for us to do a practice note and then initiate a large number of audits. There's in fact not many mortgage aggregators in the country in terms of number, noting the structure of that industry. We have regular liaison committee meetings where we ask for information on what would be helpful, and how do we develop, what other areas would be useful to develop commissioner practice notes so that we can, because we can't do everything. And so the practice note is a guide and meant to be of assistance, not a messaging of an intent around a compliance program.
How many, I know you said it's paused under COVID, maybe you take this on notice, the number of audits per year, say pre-COVID, during COVID and now as well. I assume it's a bit of a...
I'll take that on notice, but it's...
high then low during COVID, and now it's up high again. And if there's any information you can provide to us as well on the estimated gap between the self-assessment done versus the audit that that has determined how much they're able to pay. I know it's hard because it's sort of, you don't want to say one business by business, but I assume maybe if you could give a bit of information by some businesses, I assume when you do the audit, the self-assessment versus the audit would be very similar or identical. And then in other instances, it would be minor. And then in some cases, and this might be where the brokers come in, there would be quite a large gap between what they thought they had to pay and what the advice that they've been given. Yeah.
I might just point out there is actually another category that sort of slips under the radar, which is people who are subject to an audit to find out that they're actually owed a refund.
Yeah, that's very good news for them.
Yes.
Yeah. Yeah, okay.
I'll just ask this. Do you agree with the proposition that the original provisions relating to independent contractors were primarily introduced as an anti-avoidance provision?
That's a difficult question to answer, and saying that, Mr. Tudor, I hope I do have a copy of the second reading speech that accompanied the introduction of the provisions under the...
From Mr. Page?
What's that, sorry?
I think it was quoted this morning as
Ernie Page.
Mm.
So the commentary I have, this one's dealing with the 1971 legislation, the Payroll Tax Amendment Bill, a motion by Mr. Davis, while acknowledging that the provisions are designed to deal with certain arrangements that were aimed at avoiding the payment of tax. It can be a little simplistic sometimes to say that a body of provisions were brought in only for that purpose. So what often happens is that through whatever means, it could be a court case, it could be an audit, the government becomes aware that there's been a shrinking or a limitation of the revenue base, right? And keeping in mind that originally...
Or an expansion of the revenue base in this case.
Or an expansion, yes, but that's a different conversation, yeah. I believe. So they become aware that the revenue base is shrinking. Now, sometimes that's because of the thing that brings that to attention is an attempted avoidance. But the reason for the shrinking isn't always because there's some nefarious purpose on the part of individuals or businesses that are engaged in these activities. Sometimes it's just changing business models. Right? Now, it may be, though, that in order to redress that particular weakening or contraction of the revenue base, a specific anti-avoidance provision is brought in. Sometimes it's more in the nature of a clarificatory provision. And this goes then to the discussion that was had earlier. There's two general ways of dealing with this under revenue law, traditionally. One is to cast a very broad net and then to provide exemptions. The other way of doing it is to target the collection of revenue from particular activities and try and put a net underneath that with a general anti-avoidance provision. The way that the contractor provisions were brought in was the earlier type, which is cast a wide net and then set up a number of exemptions that allow various contracting arrangements to fall outside of that net.
Well, we've heard from doctors, we've heard from dentists, we've heard from cleaners, we've heard from mortgage brokers. All these industries say there is no clarity in relation to what constitutes an independent contractor and whether people are... we've heard from the New South Wales Business Council, the Council of Small Business, all of them say there needs to be more clarity around what needs to be included for the purposes of giving surety to people that they are potentially liable to pay payroll tax. Do you agree with that?
Is the inference that more clarity in the legislation?
Yes.
Do I agree that they're making that argument?
Yes. Well, no, you might not agree. Well, you can agree that they're making the argument.
Very much you agree making the argument. So I think this is a difficult question for us to answer, but I would say Yeah, from the range of submissions, and while I haven't listened to the full day today, I appreciate the sentiment that's come from them. And our strong view is that we've been administering the law fairly and consistently, and it hasn't.
Well, that can't be right. What happened between 2002 and 2016? Where is the consistency? Between 2002 and 2016, I wasn't, by the way, 2002 and 2016, what was happening? There was no consistency. There were no assessments of mortgage aggregators in that period of time.
So what inconsistency are you pointing to, Mr. Tudor?
There was an absence of assessment or audit in relating to, and this body of people, absolutely, their evidence is they were working under the assumption that they were not, because of their business model, they were not liable to payroll tax. What was happening in that period of time?
Well, we couldn't comment to what happened between those years.
But the evidence you've given is this, is that there is a changing nature of work, changing nature of contractors, and every individual case is now throwing up its own circumstances, which may or may not give rise to some sort of query. Don't you think that there is some necessity to give more clarity around what when people will be liable to pay payroll tax?
So the question you've asked could be applied equally well to every provision of every Revenue Act around the world.
Well, that's probably right.
Whether there's a lack of understanding or a lack of clarity around the definition of contractor under the Payroll Tax Act, I don't accept that for a moment. The definition is quite simple. It's very clear. The difficulty that is faced by various industry groups, which I do concede, is that as business models change, there may be a level of, or there is a level of complexity in having those business models meet existing legislation. So the underlying principle of the Act itself remains unchanged from 1941, right? Which is, it's meant to be a tax on labour, right? The provision of labour. The way that that's applied, and back then, they make clear in the, or they make the point in the second reading speech for the Payroll Tax Assessment Bill 1941, Mr. Curtin actually made that, was that it would fall largely on large employer businesses. Now, as business models change, yes, there is a challenge in meeting revenue laws, and not only revenue laws, changes in the Corporations Act, changes in the workplace health and safety legislation, pretty much everything. So I don't disbelieve anyone who has provided testimony in the hearing today at all. There was nothing that struck me from the speakers that I heard that seemed false or disingenuous. But revenue law, while in itself simple, has always had challenges because it doesn't always fit neatly with business models that are in existence. And where those issues are solved is in the courts. The courts, and look, if we jump back to the Bridges financial decision, fantastic example of my point. When you look at when you print the case out, it's about that thick. Very, very few of those pages are focused on general principles of law and of the way that the legislation operates. What probably 70, 80% of that case involves is looking at individual employees or contractors, I should say, individual contractors, and trying to apply the principles of the legislation to each of them, right? The other big challenge with payroll tax, it's a very data-heavy, numbers-heavy type of tax, as opposed to, say, land tax or stamp duty, the other two major state revenue sources. When you look at those cases, unless they're challenging or questioning a central principle, for example, what is land, right? Or how does the provision operate in this particular circumstance? In most of those cases, they're quite short. And the payroll tax decisions are large, not because the law is any more difficult, but just because the quantity of data sets that need to be considered are much longer.
Can I ask, can I just ask, so nothing has, from what I'm hearing, nothing has substantively changed from your point of view over the last since the last change in the Act, it's businesses' response to whatever other circumstances that means they change their business models. Have you been required to, say over the past 5 years, provide briefings to ministers because of a concern that there's a perception of a change out there?
I'll take that as notice, but what I would say is that this has been an issue around for a number of years in different industries. Our view has been very consistent in that we feel that we're applying the law fairly and consistently. There's obviously a lot of attention comes to certain court cases which in the main have fallen in our favour, confirming our approach. So from a briefing perspective, I think it's fair. It's very much about having that position that we've held fairly strongly to. I think what we do attempt to do is to provide the support that we can to inform others about how we think about the law and so that they can best navigate the challenges that Commissioner Smythe spoke to. But it hasn't changed, and I know the challenges where the highlights for some of those court matters that have happened in the past few years bring a lot of attention. But we're very reasonable. We will meet with people if they want to discuss their circumstances, or industry groups if they want to discuss their circumstances, so that we consider whether there's either more that we could do to inform or consider our practices even. And I think it's an ongoing relationship with business. Payroll tax is not defined by industry, it's about business models. And that's an important feature of it, particularly from a harmonised perspective, which we try to navigate through with our colleagues from other jurisdictions as well.
Mr. Johnson, just on that, we did hear evidence today from witnesses who said that their contracts, their business model had stayed the same, and they had been audited and not subject to these provisions, and yet now they hadn't changed anything, and now they were being caught. So how can that be?
So I can't speak in specific to those matters, but in general, these audits can take time as well, and I spoke of the risk-based approach we have to compliance if further information is maintained. And I'm not making inference to any of the people or the cases. Just in general, this is how we might approach. Very few businesses are re-audited within 5 years, firstly, I should say that. If there's information to suggest that there's a reason to, we'll explore that. What's also important is that while a model might stay, or the business might have stayed the same over a period of, or notionally stayed the same over a period of time, it may have grown, it may have engaged with others in different ways, and that while it might on one hand feel like they're doing the same thing in the same way, potentially there'll be cases where each year that assessment has to be made and thought through again that could be quite different to the year previous. And that's why we work with businesses who we audit to provide information, understand their circumstances, take the time that we need to.
Can I ask a question about harmonisation? Sorry, I just am not entirely clear, because you talked about harmonisation, I think maybe in your opening statement, and what exactly does it mean? Because I think we've heard evidence today of different provisions, say in WA about some things, and I think we heard in something about regional Victoria as well. So what does harmonisation mean, given that we're also saying, well, there's these differences?
So Western Australia doesn't have contractor provision, so that is certainly a difference to harmonisation. But I think in general, and Mr. Smythe will give a more detailed response, I'm sure, harmonisation is about ensuring businesses, where possible, can operate across jurisdictions and understand the legislation, the law that they're engaging with in primarily the same way. So that might mean that the rates are different. There can be other aspects of the legislation that are applied differently in different states, but the working together and understanding how we all consider the legislation quite consistently. So court cases across the country are considered in the application. There's a lot of collaboration continual collaboration with the revenue organisations across the country to ensure that we're engaging in a way that's largely consistent. That's the operational administrative aspect to that. But the point and the intent of it is really to try to minimise complexity and burden to businesses working across states.
But it's not that you have, I mean, I'm thinking about WHS as a comparison and the harmonised legislation. So it's not a direct replica, it's working where you can to come up with shared understandings.
It's probably between those two.
Okay.
The New South Wales and Victoria really pushed the harmonisation.
Right.
So we work under a 2007 Act at the moment. New South Wales and Victoria very close together, apart from one of the examples that you just pointed out. But back then, the idea was to drive the reforms that the Chief Commissioner just mentioned, trying to make it a little bit easier, especially for businesses that operated across a number of borders. So a large number of the provisions are identical right across the country. But there are, remember those old lectures on tyranny of distance when you're in high school? That's a real thing. The economies in the different states are completely different. And for various reasons, WA did not pick up a contractor regime. However, I've got a bunch of provisions that are effectively uniform. So Nexus, for example, where do you tax? How do we make sure someone's wages are not being taxed in two states? Especially if, say, they're at a place like the Gold Coast or Albury Wodonga. I won't take you through them all, right? But that's the essence of it. They're never going to be 100% unique because there are some unique provisions in each jurisdiction. But the legislation is actually set up to allow for that, so to have an area for state-specific provisions. But by and large.
So the next question to that is, so aside from WA, which is doing its thing, the contractor provisions are similar across the across the rest of the states?
Yes.
Okay.
I think the evidence was that they were waiting for us. Mr. Smythe, you quoted from the second reading speech in relation to this, I think in 1971.
Yes, sir.
Do you recall that part of that second reading speech said this bill includes a number of measures which will catch schemes designed to avoid liability for payroll tax by severing the employer-employee relationship. Such arrangements have included the use of so-called contractors to replace wages staff.
I do. I used a green highlighter to underline that.
And then if you come to the very last sentence of that paragraph, it says this, and probably you've got this highlighted as well: bona fide independent contracts will not be caught by the legislation.
I do.
And you will also recall, I assume, that it was noted by Justice Richmond in the loan market case and he said, the conclusion that the broker agreements constitute a relevant contract under Section 32 may be seen as a harsh outcome for loan markets because the contractor provisions now found in Section 32 were originally introduced as an anti-avoidance measure, which was not intended to catch bona fide independent contractors. But the way the legislature approached the implementation of that purpose was to cast the net, and this is your point, of the relevant contract very widely, and then to give exclusions which were intended to catch the bona fide independent contractor relationships, and that's the point that you have been making. Yes. Do you accept that throws up, in many respects, potentially unfair results?
I accept
and that's the position, I think, taken by His Honour.
I accept that Justice Richmond made those comments. But that's an opinion. I'd question whether it even reaches the classification of obiter, because there's no real legal view from that. I'd probably also refer to some comments made by Justice Baston in Bonner versus the Chief Commissioner of State Revenue only a couple of years ago, where in considering a similar sort of issue. He pointed out that regardless of how you feel about things, the provisions contain no requirement of tax avoidance, notwithstanding what was referred to in the second reading speech. And even if you do consider that they're an anti-avoidance provision, it's then difficult to work out what are the limits. So while the way I try and reconcile those two views, and they're not really different views, they're slightly different perspectives on the same issue, which is, as you said, the provisions are cast very broadly. The legislature at the time was very keen that bona fide independent contractors were not caught. So then we need to think, what did they mean by using that term, bona fide independent contractors? And we don't have to go very far to get the answer. And the answer is contained in the exceptions. Right? So if you are seeking services, or someone is providing services to someone that are not in the ordinary course of their business, so for example, bringing a plumber in to fix the sink in your law firm, right? They are an independent contractor, bona fide, whether they're operating by themselves or if they have a small business under them. That takes me to another of the exceptions, which is if there's two or more people engaged in performing the work, then they're going to be excluded. They're treated as a independent contractor. It can be a little bit difficult for us, a good, what's this now, 50 odd years later, to try and retrofit our understanding of what an independent contractor is now and superimpose it over the views of parliamentarians half a century ago.
But isn't that the point? Isn't that the point, that what was legislated in 1971 may not be fit for purpose today?
That's a different question.
But it is the point. But what you're saying is this model, which was in fact delivered then, might deliver a different outcome.
So I think this is the point and the question to for the inquiry. We would hold the view that consistent, notwithstanding your question, but of those early years in this century, we've consistently applied the law. Court cases have validated our approach.
You didn't apply it between 2002 and 2016.
Well, I don't think we.
Isn't there this huge gap?
Well, I think that's an unfair comment. That during that period, we would have had a compliance program that would have been, I'm sure, viewed as being fit for purpose for the time. Things have improved in terms of, as I mentioned, smarts around analytics and data sharing that's improved our practice. But I don't think we could assert that nothing was happening during that time in relation to contractor provisions. In
Can
fact,
you point to any decided decision in that gap which dealt with this issue?
Contractor issue or a particular industry group?
No, well, both.
I think the principle underlying your question, I can't speak for the Chief Commissioner, but I definitely can't agree with it. To say that we were doing absolutely nothing in that space, especially if we're talking about contractor issues.
Did you issue any practice notes?
Order.
Well, practice. We didn't.
Let Mr. Smythe answer.
Okay,
this.
sorry.
So practice notes were first issued after I became Commissioner, and I became Commissioner in 2016. So for practice notes, no. For revenue rulings, yes. And the body of case law that deals with contractors leading up to that period has continued to apply. There have been no major overturnings of the principles. When it goes back to industry groups, however, that goes back to the comments of the Chief Commissioner earlier, which was we can't and we would never want to go out and audit every single business every single year. The size of the compliance task would be immense. What we need to do is do our best to make sure people understand their obligations, and to assist that, we undertake our compliance program. But at various times, it may be looking at operators in this industry, it may be random audits of this industry, there may be spread across a number of industries. For whatever reason, the word obviously, or according to a number of the witnesses today, did not reach the ears of people involved in the aggregation industry, or if it did not
So you're telling me that
influence a change in their behaviour.
you're telling me that the aggregators give evidence that they've been in business now for over 20 years, that it's never come to your attention that aggregators may in fact be the arrangement relating to aggregators might in fact be incurring payroll tax.
So of the thousands of...
Until 2016.
So of the thousands of businesses in New South Wales that would potentially be subject for review or investigation, the 6 aggregators, I believe it is, that operate in New South Wales.
I think there are 11 across
There's a small number.
Yeah.
So I think it was 15 around the country and 6 in... Yeah, okay. But even if it was the full 15, that's a very, very small
What about
portion.
the model of doctors' practices? None of those?
I couldn't.
We couldn't comment on the
without going
specifics
back.
because we wouldn't have that in front of us. But we've not maintained a campaign of compliance efforts against medical practices either, which we've always maintained. So I think our challenge in what we're trying to say, which is possibly not answering the question or where you want us to be, is that a liability may have existed for these businesses back in these years. We couldn't comment on it. We are assessing the payroll tax each year effectively and efficiently, and arguably getting better at our efforts. And so I'm not sure what the... If the question is what was the trigger to engage these businesses, I've already answered that several times. It was about our risk-based approach, generated some audits and which have then, in the case of loan market, went to court, which validated our approach of the law. We haven't started anything particularly different or focused. What we could have communicated back 20 years ago or 15 years ago, it's impossible for us to give good value to those questions other than how we've evolved that practice and improved. So as you're aware, the Commissioner's practice notes, we are the only jurisdiction in the country that does that. They're shared and used nationally. We put a lot of effort and significant focus on trying to educate, but businesses are the ones that they have to be across their obligations, notwithstanding its complexity. We can't be an advisory service to every business in the state.
Well, the Tax Institute, are also calling for, and I think they probably sit on your panel, do they? Your consultant?
We meet with them, I think it's every 2 months, 3 months.
They're also calling for more clarity in relation to this. You say it doesn't need more clarity?
No, I don't think. I think if the law was to change, we would administer the law. We would change with it, and I think the challenge is what clarity is required for people to understand.
Well,
their obligations.
All the evidence we've heard today is from people who say there was no clarity around this, and to Dr. Kane's questions earlier, there were people who are saying that they were audited at a particular time and given a clean bill of health in relation to their audit. 2 years later, they're audited again, and what they are saying, and again, your response to this was something may have changed in the volume of the business, or some other aspect of the business may have changed. But 2 years later, they are given an assessment, but against your submission, that assessment was for a period 5 years earlier. Now, when you get the clean bill of health in 2017 and you're audited again in 2019, and you give 2019, how is it that the assessment in 2017 did not pick up this issue?
So I can't answer that question without speaking to a specific.
Yeah, it was a specific
Master.
Yeah, I think it was one of the
and I'm aware of
cases that was
the submission, but as often we're asked about specific cases,
but if that is true, wouldn't that give rise to a suggestion that you have changed your position in relation to the nature of the independent contractors that they say that they were engaging to do work on?
And I would speak generally that if we were to audit a business again, if we were to start another audit within 2 years, our practice would have been there would have been a trigger to do that by some other information that
Might
was
have been
provided.
the trolley makers case, well.
No, not as related to a business.
Yes.
So not a court case triggering us to retrospectively. So that's a very important point, actually. So payroll tax often in court and matters being considered, we're very mindful and aware, obviously, of these because we're part of those proceedings. Audits continue over these periods, and it's appropriate often, not speaking specifics to any of these people who've come here today, but you would think logically if we knew if an outcome of a court case was going to happen in a near period that may consider the law differently, we should wait before issuing an assessment. Just from a fairness perspective, that we should wait to do that. I'm speaking very generally, and I'm a bit cautious on how specific I can go to talk to certain matters.
Okay.
But the courts have continued to consider our approach as being appropriate and fair to the law.
Thank you, Mr. Johnson. Just one more question now from Dr. Kane, because we did start early and we've
kept you longer. I just have one, and it is a bit repetitive, but I just want to confirm. For example, let's take 2022 to now. There's been no substantive change in anything. So it's a hypothetical, so I'm guessing you're probably not going to answer. But if you thought that the law was not fit for purpose now, nothing has changed since perhaps there was another government in 2022. Nothing has substantively changed. So it hasn't been, if you were to subscribe that it's not fit for purpose, then it hasn't been fit for purpose for some time because it hasn't changed for some time.
Yeah,
Is that, so you think that's the case? So from when you were minister?
Order.
This is not political, Sarah.
Yeah, so I would say that's right. And the Chief Commissioner has independence from ministerial direction as well, and that's important in this function, which enables consistency over years. I would agree, nothing's substantively changed in that time.
Thank you very much, Mr. Johnson, Chief Commissioner. Thank you very much for your evidence. We started early, so we're going to finish now. So thank you very much for your...
I'm happy to continue.
I'm sure you are. I'm sure you are. You could go on for days. But unfortunately for you, Mr. Tudor-Hope, we have got other things to do, other committees to get to. So thank you very much for your evidence. Thank you very much for your submission. Thank you very much for your work on behalf of the people of New South Wales. A few matters taken on notice. Secretariat will be in contact in due course. Thank you very much. You're free to leave. Thank you.
Thank you.
Thank you.
Thank you very much.